last Friday. I have downloaded a server copy. Only the income portion would be changed. Everything is all right, Your Lordship.
Let it be taken up.
Your Lordship,
Let it be taken up today.
Your Lordship, kindly fix it at any time today, Your Lordship.
Today it is in the list. Today it is in the running in the list.
Yes, Your Lordship. May not be reached, Your Lordship.
May not be this. So how can I? Let's see. What can
Your Lordship, kindly.
not necessary to mention.
Your Lordship, kindly.
Already in the list.
At the time of rising, Your Lordship can take this matter, Your Lordship. If it is not reached, Your Lordship.
Let me see what is going on
Your
there.
Lordship.
Okay.
My lord, may I permit to mention there's a
What is the purpose of mentioning today? We have only 2 days now.
Lordship,
Your
the
Lordship.
interim order is expired on 7th of April in both these matters. The extension for the interim order.
Then it has to be mentioned earlier.
It should be taken up on Friday under extension of.
Friday, the list is running 86, 87 like that. All will be there.
Lordship, the interim order is already expired. Please prove.
Extension of interim order, criminal motion, already there. Several matters are there. Last day, I have my staff to go to the Calcutta. There are fixed tickets. I cannot detain them. This is the difficulty.
Lordship, kindly extension matters kindly maybe hard. Lordship, I have another matter, extension of interim order.
Your Lordship, on 5/4/24, typographical correction you needed, Your Honor. And also.
Okay. For correction.
My lord, may I permit to mention on criminal revision?
Criminal division?
For inclusion in the list.
No.
Lordship, may I be permitted to mention a matter? Your Lordship, Mr. Rajdeep Majumdar is appearing virtually to mention an urgent matter, Your Lordship.
My lord, with your lordship's leave, my lord, may I be permitted to mention one extreme urgent matter? My lord, these are all, my lord, senior officials of HDFC Bank. My lord, just to, my lord, I am Rajdeep Majumdar, my lord.
I understand. Only 2 days here.
My lord, I want this matter to be moved today at 2 p.m. I want your lordship's leave, my lord. It's an extreme urgent matter. Otherwise, I
What is the
would
matter?
not have disturbed your lordship. My lord, this matter is, my lord, they are all senior officials of HDFC Bank. A FIR has been started by a nursing home saying that the swipe machine which have been provided, we are charging from them. Only on this allegation, a FIR of 420, 406, 467 has started. All senior officials are involved. Otherwise, we would not have mentioned your lordship. This is a pressure tactics, my lord, to get the, my lord, settlement. We have provided the swap machine as per the terms and condition he was supposed to pay. He is not paying the money and FIR has been started against us, my lord. At 2 p.m., my lord, if your lordship kindly, my lord, permit me.
You have preferred the revision.
Yes, my lord, that is, my lord, if your lordships give leave today, then we can move it to today at 2 p.m. This is the usual practice. My lord, on urgent basis, my lord, we move this kind of matter at 2 p.m., my lord. And now, my lord, the police is chasing this HDFC personals. My lord, kindly, my lord, take up this matter at 2 p.m.
Move it on Friday. I am giving a leave to move it Friday. Friday, my lord, kindly, my lord, 11:30 then, my lord, 11:30, my lord. It's a request. Okay. Friday.
Lord, deeply obliged.
And Friday. Call the list.
Item number 1. My lord,
Yes.
in the judgment of the page number 5, the last line,
Yes.
the enhanced compensation is 4,72,320. It would be 4,82,000, 8,200, 320. The calculation mistake.
Calculation
Only
is
calculation mistake.
arithmetical error.
Arithmetic error. 4,82,000 would be. And in the last page, page number 6,
There will be same.
the balance comes to 4,82,000.
Balance award is like that. Have you made calculation?
Yes, the calculation has been made.
16,61,520 is the award. Tribunal awarded 11,79,200.
200.
0.
The difference is 4,82,320. This 4,72,000 it has been made. Actually, it would be 4,82,000.
82,000. Okay. Please take down. This matter appears for correction. in the judgment dated 5/4/2024 at page 5 in the in the last line, the enhanced compensation was erroneously mentioned as 4,72,320. Stop. There are arithmetical error. The correct enhanced compensation would be 4,82,320. Stop. Next, similarly, at page 6, in line 4, the said balance award shall be correctly read as 4,82,320. Remaining portion of the order would remain the same. Next.
With the permission.
Acha. ছিল 2020 আচ্ছা বলে দিচ্ছি 23 ছিল 20 আচ্ছা in order number 5 it appears for correction legal this matter appears for correction in order number 5 order dated 5/4/2024 and the third line the serial numbers with the year should be interchanged in their place. Should be interchanged at their place. Next.
Yes, Prashant, for the position. Correction.
Ram Vijay Azad.
Wrong, Vijay.
Run.
Run, RAN.
RAN.
Yes.
RAN. Run.
Instead of Ram, it should be.
Yes. In this matter appears for correction. In order dated 5/4/2024, the cause title of the said order regarding the name of the petitioner should be correctly read as Run RN. Run Vijay Azad.
Yes.
Alias Run Vijay Azad instead of Ram Vijay Azad.
Okay.
Number 4.
আচ্ছা
স্টেটের নামগুলো তো দেওয়ার দরকার নেই, আছে তোর মধ্যে না?
আচ্ছা this matter appears for correction in order dated 8/4/2024 at page 4 the CRAN number should be read as CRAN 3 of 2023 instead of CRAN 1 of 2023.
Number 5 and 6.
Shift to mathematical or arithmetical error is there at page number 1.
Page number 1.
Page number 1, line number 2. The date of 12/22/12 should be there. Instead of 22.
What is the date of judgment?
Uh, date of judgment, 22nd December 2022.
22nd December 2022. Okay.
Another in page number 2. Page number 2, para number 3.
Page number 2, para number 3.
May I read? The learned tribunal has awarded a sum of rupees 40,25,05,0656 instead of 40,25,066.
What was the award? 40 lakh 24
25,066.
066.
066.
066. Okay. That's all.
Yes.
Please take down. This matter appears for correction. There are some inadvertent typographical mistake at line number 2 of page 1, wherein the award on the date of the award should be correctly read as 22/12/2022. And the next page at paragraph number 3, paragraph number 4, paragraph number 4, the awarded sum was erroneously mentioned as rupees 40,25,0656. It should be read as it should be read as rupees 40,25,066.
066.
066. 7%.
Take your worship.
Call the list.
Item number 7.
I'm for the opposite one, 1 to 6.
7, Millard, is a part-head matter. Millard, I am otherwise ready with the matter. Millard, I have to show 2 judgments. Millard, kindly takes it up, Millard, on the second call.
Why?
Millard, the judgment, sir, Millard, it is getting printed. It might take Millard 10-15 minutes to reach me.
You know, this matter was supposed to appear on Monday, but it is appearing on Wednesday.
What is the matter?
Millard, sir, rejection of application under Order 39, Rule 7. The lower,
Rule 7.
the learned lower court has rejected it on the ground that it would tantamount to fishing of evidence. Now, Millard, my contention is very simple. My contention is that considering the fact.
Okay, I understand. I got it. When you are coming?
Millard, but if Millard takes it up at 2 p.m. Millard?
No, all matter cannot be take 2 p.m.
Millard, I'm not aware.
Let me go to the list. First call. Next.
So on the second call, Millard.
Next.
Item number 9. Appearing for the petitioner. An application for quashing of the FIR. But what has happened? There is a dispute between 2 brothers. Long standing civil dispute. Now one brother has come up with a story. I will tell you, Lordship. The father of the petitioner had several properties. He divided them among the legal heirs. Now the de facto complainant time and again tried to encroach upon my property, the petitioner's property. They have tea gardens. When he could not succeed, we filed a civil suit. We got an interim injunction. He could not succeed in civil court. Now he has lodged an FIR saying, I have stolen tea leaves worth rupees 60,000 from his tea garden. This is the crux of the matter, man. Only non-bailable section is 379. He says, I went to his tea garden, I plucked tea leaves, 3,000 kilo tea leaves, and I fled away with that. This is the only allegation. Several civil litigations are there. When he could not succeed in civil court, he has lodged an FIR.
Let them come, let the matter be disposed of. Okay, please take down.
Meanwhile, let there be a short stay, madam.
What is the purpose of stay?
Madam,
Let the state come.
now what has happened, my lord? The charge sheet has been submitted.
Charge sheet submitted.
That is why I am praying for a short stay.
You have challenged the charge sheet here?
We have filed it for the FIR. After filing this application, this is pending, the charge sheet has been submitted. Now the charge sheet has been submitted, well, it will be a short statement.
Then you file one application, separate application for challenging the charge sheet.
Now, liberty may be granted to file a supplementary affidavit. We will place the charge sheet on record, but meanwhile, let there be a short statement.
Have you got the copies?
But copies are yet to be supplied.
Then
It is on record that charge sheet has been filed. We went to get the certified copy, we did not get it. But let there be a short stay, my lord. Only 379 is there saying that I have stolen tea leaves, several civil litigation. It has gone till the Honorable High Court also. And there is content proceeding also pending against this de facto complaint. But only because he could not succeed in civil court, he has lost this complaint. Your Lordship would kindly see the FIR.
okay, please take down. This is an application under section 482 of the Code of Criminal Procedure for quashing a proceeding of GR case number 1947 of 2023 arising out of Bagrogda Police Station case number 232 of 2023 dated 1st June 2023 under section 447 379 stroke 34 of IPC. Stop. Next, learned advocate for the petitioner submits that a long-standing civil disputes are going on between the opposite party and the present petitioner. Stop. The opposite party only lodged the false written complaint on the ground of theft of tea leaves amounting to rupees 60 lakhs. Stop. The
60,000 miles.
60,000. The allegation on the FIR is false and concocted. The present petitioner and the opposite party number two are the full brothers. Full brothers, and ancestral property is the main cause for the dispute. No criminality can be proved in this matter. Accordingly, he prayed for necessary order. Stop. Having heard the learned advocate for the petitioner, I find he demonstrated a good arguable case in this CRR. Accordingly, the instant CRR be admitted. Stop. Petitioner is directed to serve the copy of the instant petition along with the annexures thereof to the opposite party and file an affidavit of service on the returnable date. Let the matter be returnable in the next ensuing circuit bench. Stop. Next, considering the facts and circumstances of this case, there shall be a stay of operation of the impugned stay of operation of the GR case number 1947 of 2023 pending before the learned Chief Judicial Magistrate Siliguri till 24th May 2024 or until further whichever is earlier.
I am deeply obliged. But leave may be granted to file this application.
No, you file take the leave from the.
I am deeply obliged. Much obliged.
Yes, Mr. Poddar.
My lord, this is the quashing of the proceeding, my lord. Charge sheet submitted under section my lord, 341, 323, 354, 506, and 34 of the Indian Penal Code, my lord. There are two accused persons, there are two petitioners, both the accused persons before your lordship, father and son, my lord. My lord,
Father and son.
both, my lord. So on 14th of July 2022, my lord, we lodged a complaint before the police station, my lord. This is this first complaint, my lord. On page 21, my lord. Against the de facto complaint, my lord. And this is the registered as GDNP, my lord.
Poisonous gas discharge from,
My neighbor dispute, my lord. This is my complaint, my lord.
he is the,
My complaint, my lord.
this is your complaint.
Yes, my first complaint on 14, my lord. And they lost.
21, it is your complaint.
Yes, my lord, my complaint.
July 14.
Yes, my lord.
Then where is the complaint?
19, my lord. Page 19 is the there is the affair.
Their complaint.
Yes, my lord.
It is dated
My lord, it is dated on 18, my lord.
18th of
8th July.
July.
Yes, my lord.
So what is the charge sheet?
My lord, charge sheet, my lord, page next, my lord. Page 22, my lord.
Apropos FIR.
Yes, my lord. Thereafter, my lord. Page 22 on our charge sheet submitted, my lord. I annex.
Okay, please take down.
My lord, there is no statement of victim recorded under section 164. This is the mandatory after amendment of 2013, my lord. There is no 164 statement. If your lordship
Have you
kindly-
got the copies?
Yes, my lord. If your lordship kindly see the charge sheet reveals that, my lord. Page 24, my lord.
Read out.
My lord, read out, my lord. First paragraph, last two line, my lord. Accordingly, ASI Prosenjit Ghosh took up the investigation of this case. During investigation, I take necessary investigation step and examine the complainant wife victim, namely Joya Ghosh De Sarkar, and recorded her statement under section 161. If your lordship kindly page 23 also, my lord, list of witness, my lord, in here also recording statement, my lord, under section 161, my lord, list of column, my lord, particulars of witness to be examined, my lord. Joya Ghosh De Sarkar, my lord, recorded statement.
CS witness number 6.
Yes, my lord.
So
And
what-
another thing is, my lord, there is no medical, my lord. Maybe to 323, my lord, they never treated any hospital. There is no investigation regarding that, whether they treated any hospital. There is any
It is
medical.
required under section 323
Malad-
to go to medical.
But it's not required, my lord, at best. If he suffered any injury, because he's saying that there
Okay, let me see. Let me see.
bodily injury, whether any bodily pain, my lord, there is no. And incident on 15, my lord. He lost this complaint on 18. Earlier, I lost this complaint on 14, my lord. Neighbor dispute and ingredient of 354 not kept out, my lord.
Okay, let the you serve and come.
And
Already charge sheet submitted.
here's my charge sheet submitted.
Please take down. The instant CRR has been preferred for quashing the proceeding being GR case number 1191 of 2022. Pending before the learned Chief Judicial Magistrate, Coach Bihar, arising out of Kotwali Police Station case number 797 of 2022, dated 18th July 2022 under section 341, 323, 354, 506, stroke 34 of IPC. Stop. Wherein a charge sheet has been submitted under section 341, 323, 354, 506, stroke 34 of IPC. or the learned advocate who submits that the instant FIR is the counterblast of a complaint of the present petitioners dated July 14th, 2022. He further submits that the investigation of the police is perfunctory. Stop. Considering the charge sheet and the report of the police thereof, it appears to me that the the state is required to be heard before admission of the instant criminal revision. Accordingly, the petitioner is directed to serve upon the state and serve of the state and file an affidavit of service on the returnable date. Let the matter appear in the list on the next ensuing circuit.
Limited stay, my lord.
No, no. Please take down. Yes, next.
Your lordship, I'm praying for a lordship, I'm praying for a short passover, your lordship.
Again, Shobha.
The council is before court number 2 on his legs.
Taking a password, it's okay. But for the first time I appeared.
Yes, your lordship.
Yesterday I just got the brief. Let me prepare.
You are appearing?
Open number 1. I'm for the state. He is for the state, I'm the open number 1, she is the petitioner.
He is on.
Seeking password, it's okay, but for the first time I'm appearing.
Oh, he has
So the
not been-
hearing cannot be concluded today or in this.
I am for the petitioner, my lord, in this case. My lord, this is the affidavit of service.
This
There's allegation of a misappropriation of near about 80 lakhs.
Yes.
So CD is required.
CD or a CR case.
No, it is not a case of
CR case.
It is a complaint case.
Yes.
And there is a dispute between transaction between myself and the petitioner. And let me clear my.
आगे आमी बोली.
One thing. Just for the yesterday night, I got the it. So I have to pay. There is a bunch of documents were there. The matter may be fixed at any day. So your lordship.
Next circuit.
My lord, my lord, my lord, my lord.
Next, this circuit cannot be.
No, no, my lord. Lordship may fix it for next circuit. He probably willing to give opposition, but my lord, I am praying for an interim stay, my lord, in the
No,
meantime.
no, no.
My lord.
Because no, stay cannot be allowed. Because
Okay, very well, hard.
My lord, this company is situated in Visakhapatnam, my lord, in the state of Andhra Pradesh.
No,
My lord,
maybe.
Dalam, dada.
Okay. Please take down.
No, you are the debtor. I am the creditor.
Okay.
You have to bypass your liability.
That is what, my lord, this is a commercial transaction.
Liability.
This is a commercial transaction, my lord, a criminal case is
I am
not
not hearing
pending.
any one of you.
Malad.
I am not hearing any one of you. Affidavit of service filed on behalf of the petitioner is taken on record. Opposite party is represented and submits that he wants to use affidavit in opposition. State is also represented. Stop. Learned advocate of the petitioner sought stay. 6 an order of sought stay. Stop. Considering the next, considering the facts and circumstances of this case and considering the matter that all the parties have appeared in this matter, accordingly, the matter can be disposed of on merit. Accordingly, let the matter be posted for hearing in the next available circuit.
My lord, the only difficulty is, my lord, I am located in Visakhapatnam. And my lord, in the trial court, my lord, I have to appear personally. That is why, my lord, all the directors are implicated of this company.
Next circuit, you move to next circuit.
If they are
ready.
prevented by
That is ready. Can be heard.
the 12th is there.
But my lord, in the
I can also heard it, but the only 2 days left. Otherwise, I can dispose of it. Only
very
2
short
days
matter,
left.
my lord.
No, only 2 days left. How can they have to give the, otherwise I will.
Lord, that is why I was praying, my lord, a short stay if could be granted, my lord.
No, stay is the matter, the contested matter. How can I give the stay? All the matters are there.
Lord, he has appeared today only, my lord. Since the matter is pending before the trial court and I have to travel from
What is the
Visakhapatnam.
late date? What is the date?
June mas.
In the month of June.
In the
My lord, in the month of, no, in the month of May.
May. Prior to that,
In the month of May, that is the,
disposed of.
yes, April will be the next circuit is April.
My lord, then, my lord, kindly one observation, my lord, if on the next occasion, if he does not give the opposition, my lord, I can renew my prayer for stay.
That is the matter of the learned presiding judge. Okay,
That's
not me.
well,
Please take down. Please give me the next one.
item number 12. Madam, I am for the petition. Oh. Hello. Madam, in this case, madam, I am for the petition. Stay there. Madam, actually, madam, so for the case is concerned, we have filed the case to vacate the ex parte order, my lord. And so for the main order against which we are praying before lordship, that is the, I think, page now 15 and onwards, that 15 to 19, where the order of maintenance was allowed against me ex parte, my lord. And if I got a chance to oppose that application and file an application as 126(2), I can divulge my defense, my lord. But in this case, my lord, it is a very astonishing and in mechanically after passing an ex parte order, immediately an order of prayer for execution was made before the Lord executing court, and directly without observing all legal formalities, directly WA or DW was issued. So my humble submission before lordship, the matter may be stayed. I may be get an opportunity of being heard, and after that, whatever will be the fate of my application, that will be later on.
You have challenged
I have challenged the order, my lord.
order under section PWDV Act.
My lord. Section 12 of the PWDV Act, my lord. That is the page now 15 to 19, my lord.
10,000 and 20,000.
My lord. Actually, I am nothing but a mere hawker of situated at a shop in the roadside and under the Jalpaiguri police station, my lord. But in an ex parte order, an excessive amount was awarded against me. So my humble submission that impugned ex parte order may be stayed. I may be permitted to appear before the trial court. I will divulge my case.
Order dated 12th of August 2021.
My lord.
Now we have 24.
My lord, I have filed this case, my lord, the year of 2024.
Then
My lord, so for the case is concerned, that is the one limitation
not
point is there.
yes.
My lord.
Then it cannot be admitted. You prefer a separate application.
My lord, my lord, my lord. I may be
Okay.
permitted to file an application as in 5 of the Limitation Act, my lord.
Please take down. The petitioner is at liberty to file an appropriate application in connection with the instance here. Let the matter go out of the list.
Thank you.
Next.
Item number 13.
Yes, what is this?
My lord, in this application, I have challenged the warrant of arrest issued by the learned trial court before filing of charge sheet, my lord. Now, if my lord comes to page,
Before filing of the CS.
yes, my lord. My lord, if my lord comes to page 40 of my application, page 40, my lord.
Yes.
This is the application for prayer of warrant of arrest made by NCB.
Yes.
My lord, the mere perusal of this document shows that they have deposed falsely before the trial court below and taken the order of the warrant of arrest. Why, my lord? Kindly come to the paragraph 2, my lord, of the application. Paragraph 2. The entire search and seizure procedure was conducted on spot in presence of all the team members, 2 independent witnesses and Amjad Mia. The fact of the case is, my lord, some contrabands were found from the house premises of this Amjad Mia. He is the father of your petitioner in this instant case, my lord. My lord, here, my lord, they have wrongly submitted that 2 independent witnesses were there. Now, my lord, come to page 29 of my application. Page 29, my lord, Annexure P2. Second last line from bottom, my lord. Second last line from the bottom. No one could be associated as independent witnesses from the locality.
What is this?
The
Search cum seizure list.
Yes, my lord. The team of NCB tried their best. Third line from the bottom, my lord. The team of NCB tried their best to associate the independent witnesses from the locality, and due to oddity, I don't know what is the meaning of that, odd hours of time and close border locality, no one could be associated as independent witnesses from the locality. This is their statement in the search cum seizure.
What is your status? Who are you?
I am the son of the person from whose
You are the
house.
son of the accused.
Main accused, my lord, principal accused. I am the son
Mia.
of. Yes.
So
I was not present in the house premises. First, my lord, I was not present there. I was not arrested, my lord. My father was arrested with the contrabands, my lord. They have taken warrant.
So why they pray your warrant of arrest? Are you
They are,
treated like
implicating me as one of the
Accused.
main accused.
Okay.
That's why they are
Okay.
paid for this warrant of arrest. Now, my lord, another. They are making their case that the house premises from which the petitioner, the contrabands were found, was resided and belongs to me, the present petitioner before you, my lord. These are the house deed, my lord, of 2 persons. One Amjad Mia and another one is, my lord, Asraful Alam. I am for Asraful Alam. Both the houses are different, my lord, and are not same. But their story in the case is that
these are the merit. Why they have connected you as accused? That is not the question here. You have questioned your order.
yes, my lord, I have questioned the order, my lord, because the order is at page, my lord.
Show me the order.
Yes, my lord.
Why you challenge this?
Order is page, my lord, just 28. No, not 28. Order is at page. Yes, my lord, 39. Order is at page 39.
Order dated 20th of December.
20th of December 23.
Yes.
Order number 26.
Your anticipated bail was turned down.
Turned down, and on the same date, my lord, warrant was issued. On the same date, my lord, warrant was issued. My question is, my lord, whether the trial judge can issue warrant first when the application for bail is, anticipatory bail is moved, second, before filing of charge sheet.
No, you was arraigned as an accused,
My lord,
primary accused in this case.
my lord, the NDPS Act.
FIR name charge sheet you were.
No, my lord, not FIR name. FIR has been initiated against Amjad Mia. From Amjad Mia, my name transfer. That is there. Kindly come to the seizure search cum seizure list, my lord.
Where you?
Page 29. Kindly see. Well, page 30. 30 is
So
the,
you were termed as a accused
yes,
by the investigating agency.
yes, my lord. My lord,
So,
if my lord comes to
During,
my lord,
during investigation, what is the purpose
My
of the
lord.
trial court?
30, my lord, page 30, my lord, once, page 30.
Page 30 is the search and seizure memo
Yes, my
report
lord.
by the investigating agency.
Yes, my lord. My lord, the very first paragraph, my lord, 1, 2, 3, 4, 5, 6, 7, 8, ninth line, my lord.
Yes.
On being asked, the said person introduced himself as Amjad Mia, father of his elder son, namely Asraful Alam. On asking, he disclosed that he did not know the whereabouts of his elder son, that is Asraful Alam, and he further stated that his elder son Asraful Alam lives separately, and then on being asked, he showed the portion of the house lived in by Asraful Alam and his wife and kids. Then the team revealed the secret information. Well, from this paragraph, they have come to know about Asraful Alam on the basis of the statement recorded under section 67 of the NDPS Act.
Yes.
On that basis, I was implicated. My lord knows very well that section, any statement recorded under section 67 is not.
Whether it is admissible or not, that would be matter of
My
trial.
lord, Tufan Singh has already
Yes.
stated that it cannot be admissible.
Very well. You have the ground. Very well.
This involves quantity of narcotics.
No, he cannot stay at this stage because this is the administrative stage until the court issue the rule to serve them a copy.
No, I
But he can attend. He can attend.
My lord,
I have the right.
as your lordship pointed out, though my learned friend never uttered the word, his prayer for anticipatory bail has been turned down. He has come up with second prayer.
My lord, my anticipatory bail was filed prior to this application and that was turned out.
No.
The second application has been filed recently, my lord.
Okay, very well, very well.
My lord, and that
And that do not prejudice me from moving this application or placing my submission before this court. my lord.
It is only trying to mislead the court.
This is not misleading.
Yes,
This is not misleading.
Okay.
When you will get your opportunity, then
Okay, hard.
submit that.
Okay,
That's
hard.
right.
Lordship, is my.
I have got the matter. I have got the matter. You don't have the matter. This is an application under section 397, read with section 401 and section 482 of the Code of Criminal Procedure for quashing and set aside the impugned order dated 26, order dated 20/12/2023, passed by the learned special judge NDPS Act.
My lord, one introduce.
Yes.
Can you consider my prayer? My lord?
Okay. Comma, additional district session judge, Fast Court, Coach Bihar, in NDPS case number 45 of 2023, arising out of NCB crime number 25 stroke NCB stroke call stroke 2023 dated 21/8/2023 under section 8 within bracket C, read with section 21 within bracket C, stroke 22 within bracket C, stroke 29 of NDPS Act. Whereby, no, stop. Learned advocate for the petitioner submits that the
My lord, one more indulgence, my lord. The principal accused Amjad Mia has been granted bail by the trial court.
okay.
That order is also annexed here, my lord.
So that has been challenged.
That they have challenged, my lord, but it has been granted.
Okay, that is not the issue here. Learned advocate for the petitioner submits that he was arraigned as an accused in this case by the prayer of an investigating agency, and he was connected with this incident commission of offense by the statement recorded by the investigating agency of the principal accused persons. Stop. He further submits that the bail prayer of the principal accused persons was considered and allowed by the learned special judge. But when the present petitioner appeared before the learned, no, when a prayer for anticipatory bail was moved before the learned special judge, the same was moved before the learned special judge, the same was turned down. And on the same order, same impugn order, the learned special judge has issued the warrant of arrest against the present petitioner. Stop. It submits that the investigation conducted by the investigating agency is not according to the provisions of NDPS Act. Stop. The present petitioner has been falsely implicated in this case. Stop. Having heard the learned advocate for the petitioner, and after considering the materials placed along with the instant petition, it appears that the investigation reveals that 100 bottles of fentanyl, 235 grams of jojoba tablet or yoba tablet, one country-made pistol with live ammunition and Indian currency amounting to rupees 43,76,000 was seized from the PO. Stop. The question of law involved question
PO,
of
my
law.
lord, of Amjad Hussain. my lord.
Whatever may be the PO cited by the IO. It's an investigating agency. You know? Point of law. Canvassed by the learned advocate for the question of law. Canvassed by the learned advocate for the petitioner cannot be decided at this stage without having heard the investigating agents. Accordingly, the petitioner is directed to serve a copy of application along with the petition along with the annexes thereof to the investigating agency, to the opposite party, opposite party, and file an affidavit service on the returnable date. Stop. Considering the facts and circumstances of this now, let the matter appear in the list on the next available circuit. Next, considering the facts and circumstances of this case, I find no justification to issue an order of stay.
My lord,
In
it
fact,
is necessary, my lord, because the case is ongoing before the trial court, and if the warrant of stay is not being granted, my lord, it will cause great prejudice. My lord, I have gone through the record, my lord.
I have already given you the fix next.
You can give, my lord, 7 days also stay, because next circuit is from 22nd.
Yes, come on to 22nd. What is the difficulty?
My lord, kindly
I have
grant me 7 days.
I have heard properly the IO. Otherwise, your prayer for anticipatory bail was turned down. Without hearing the IO, I cannot heard the
My lord,
when it passed in order.
My lord, the prayer for anticipatory bail was turned down, and on the same page, my lord, same order. What? My lord knows better than me.
No,
Can
I
you
understand. I understand. I cannot divide the order.
My lord,
Cannot divide the
yes,
order.
my lord.
Anticipatory bail order.
I
is there.
can understand, my lord. That
Yes, I understand. I understand.
Kindly pass for 7 days stay, my lord.
No.
Kindly, my lord.
No.
It's a humble request. Otherwise, my lord, it would cause great prejudice.
No, you just hearing.
My lord, kindly, my lord. Kindly.
Next.
My lord, kindly, my lord, give me 7 days. 7 days, my lord. I'm not asking for much more, my lord. Kindly, my lord, 7 days, my lord.
If
It
it
will cause
appear
prejudice.
in the first week of circuit, then I can heard the matter.
My lord, it will appear in the 22nd. The
Yes.
circuit will sit on 22nd. Let me
No.
give and stay for that time.
Logically, the
My lord,
hearing.
if I, my lord, tell you,
Logically, the
arrested right now.
No.
If I've been,
Why
they will
you are
arrest me.
Why you are
Because there is
pressing
no, they
hard?
will arrest me. And if
Why you are pressing hard? The bail application or anticipatory bail application cannot be heard without the presence of the IO.
my lord,
You know.
I know that.
In this NDPS
Interim
case also.
protection I am seeking for.
No,
If I am
injury
being-
protection,
No,
no.
my lord, if I am arrested tomorrow or today, then this application will become infructuous. There will be no.
No, I don't.
Kindly appreciate that this application will become
Okay, okay.
infructuous, my lord. Kindly, my lord.
No.
Kindly, my lord. Otherwise,
Next,
this
next
application,
matter.
my
Next.
lord, this application will become infructuous. Kindly
Lordship is
appreciate
taking
that.
up 14. My lord, learned junior of the conducting advocate in item number 14.
My lord.
My lord,
will cause.
I have completed the matter. No,
Lordship,
no.
kindly see the name of the petitioner in 40.
The application will
No, I have already heard. Nothing to heard.
application will become infructuous.
No,
Then
no.
what will be you?
Sir, I have already completed. How? What is the your conduct in now? Why are you pressing her? I have already passed the order.
That, my lord, in that, so let me withdraw the application.
No. I have already
Let me
passed the
withdraw the
order.
application.
No, after hearing, after.
My application will become infructuous. My application will become infructuous.
Very well.
Then
Why
allow
are
me
you
to
pressing
withdraw the
hard, sir?
Allow me to-
After hearing all the matters.
Allow me to withdraw the
No,
application.
that cannot be done like that. I am online. I cannot withdraw like that written order. Okay? This is not like that. This is not the procedure. You are arguing like.
If the application will be infructuous, what is
If
the
you want,
use, my lord?
I shall sit out from the bench, chair. What is your conduct? No. Yes, next.
The name of the copy in item number 14 is very peculiar, as my lord noticed it.
Lordship, item number 40 kindly thought pass over.
Again, pass over.
My lord, just notice the name of the party, my lord.
12 PM.
It is very significant. My lord's court has become Nuremberg trial court. My lord is trying Hitler.
Lordship, kindly
It will leave, my
shortly.
lord.
No, what is this? Our next circuit.
Lordship, kindly fix it 12 PM. Lordship, kindly.
All the matter is fixing and
Kindly.
we have only 2 days. How can we
Lordship,
accommodate?
kindly.
Okay, first call. Next.
Item number 15. But I have for the petition. My lord, this revisional application, my lord, claims its origin from, my lord, the Kotwali police station case number 287 of 2022. My lord, for, my lord, quashing of the, my lord, entire prosecution case. Now, my lord, the fact of the matter is that, my lord, the petitioner herein is a, my lord, bank employee. He used to, my lord, work in the Axis Bank Coach Bihar branch. My lord, all on a sudden, my lord, the branch manager of that, my lord, bank, but all on a sudden, my lord, lodge a complaint against the petitioner that, my lord, amount of 24 lakhs in total, my lord, from 4 account holder. That amount has been, my lord, the money has been, my lord, misappropriated by this particular petitioner from the banking transaction. Now, my lord, what happened thereafter, my lord? That entire amount of misappropriated money, alleged misappropriated money, has also been, my lord, retransferred, credited in favor of those account holders by the bank authority. My lord, thereafter, my lord, I obtained anticipatory bail from the learned court below. Well, this is the server copy. And my lord, the learned court below was pleased to observe that the entire alleged misappropriated money has already been recredited in favor of the account holder. That is, my lord, the observation, my lord, paragraph 4. And on that context, my lord, I have been enlarged on bail by the learned court below. It's absolutely, my lord, frivolous application, my lord. The entire amount was, my lord, floating on, my lord, the, my lord, banking transaction scheme, online scheme. My lord, a fault or my lord, any, my lord, online, my lord, fault has been propped up. On that presumption, my lord, the branch manager, the complainant, my lord, filed that, my lord, complaint against me. And thereafter, that fault has been, my lord, recovered. The amount has been credited in favor of the, my lord, account holder. And, my lord, I obtained the bail.
The complaint of 2022.
Yes, my lord. And thereafter, my lord, charge sheet has already been filed. So far, my lord, I have been instructed. And my lord, the charge sheet also reflects, my lord, that the my lord amount has been, my lord, credited to the my lord account holders.
There may have no complaint from the account holders, but the bank have the.
Yes, my lord. So that is very surprising, my lord, that no complaint has been, my lord, initiated by the account holders, whereas, my lord, the branch manager became the, my lord, the complainant and filed the, my lord, the complaint, my lord, the complaint. Whereas that bank, my lord, itself, the branch manager, on behest of the branch manager, the entire amount has been credited. So it, my lord, presupposes the presumption that, my lord, it was a, my lord, online, my lord, fault.
No, there is no such finding that the online fault is there.
No, my lord, that was, my lord, it is my presumption, my lord, but the amount has been credited in favor of the, my lord, the account holders.
Where is the charge sheet?
My lord, charge sheet, my lord, it has not been annexed as because, my lord, it has not been seen, my lord, the cognizance has not been taken by the learned court below, but it has been filed by the investigating officer.
Which member of the state, let the case identity qualify and seek for the report also, my lord, whether the misapproved amounts have been credited back to the account holders or not, my lord.
No, it is
My lord,
it is not the complaint of the creditors or the account holders. It is the complaint of the bank.
Bank, my lord.
Whether you have taken any statement from the bank or the
CD is required, my lord.
CD is required.
My lord, during this time, my lord, a short stay, my lord.
What is the purpose of stay? The cognizance has not been taken. I am fixing that.
My lord, the GR case has already been registered, which originates from the PS case, my lord.
Let the report. Let a report be called for.
My lord, what
Regarding
happened?
the statement
My lord,
of
what
banks
happened, my lord?
or the account holders.
My lord, I have been ousted out from the bank. My lord, my salary and my lord, my all benefits, my lord, salary benefits has been withheld by the bank authority. So, my lord, until and unless there is a stay,
You have a good merit in this case.
Lordship.
Let me peruse the statement of the bank officials.
As you lordship pleases.
Otherwise,
But, my lord,
it is not.
there is a, my lord, maybe a short, my lord, stay, my lord. Otherwise, my lord, I won't be able to get, my lord, the salary benefit.
That is the first day of next circuit. Okay.
Yes, my lord, yes.
Please take down. The instant appeal, instant CRR has been preferred against the preferred for quashing a criminal proceeding being Kotwali PS case number 287 of 2022 dated 24/3/2022 under section 120B 409 467 468 471 and 422 IPC corresponding to GR case number 440 of 2022 pending before the learned Chief Judicial Magistrate Coach P. Stop. Next part. Learned advocate for the petitioner submits that the petitioner is a bank officer. An amount of rupees 24 lakh was alleged to have been misappropriated by the present petitioner, and the bank manager has lodged the instant complaint with the police. However, it appears that the bank has already credited the said amount of rupees 24 lakh to the accounts of the account holder. Accordingly, the present petitioner was enlarged on bail. Stop. The learned trial court at the time of passing the order of bail has perused the CD wherein the statement of the account holders were recorded regarding credit of the said misappropriated amount. Stop. For the learned advocate, considering the facts, it appears that the learned advocate for the petitioner has demonstrated a good ground in the instant criminal appeal. Stop. However, the merits of the instant criminal revision cannot be determined without perusing the CD. Accordingly, the petitioner, according to the instance CRR be admitted. Stop. The petitioner is directed to serve the copy of petition along with the annexes thereof to the opposite parties and file an affidavit of service on the returnable date.
Lordship, I've been served.
Let the matter be posted for hearing on the next available circuit. Stop. Considering the facts and circumstances of this case, there shall be an order of stay of the further proceeding of GR case number
Lord, GR case number, my lord, 440
440
of
of 2022 pending with the London Chief Judicial Magistrate Coach Beer till the first date of circuit, to the first date of next ensuing circuit bench.
my lord, it would be, my lord, it ought to have been, my lord, special EC Act come additional session judge second court, my lord. That is, my lord, this is the second page of the server copy of the bail order, the designation of the court, my lord.
No, I have read out from your petition.
My lord,
Learned Chief Judicial Magistrate Coach Beer.
no, my lord. My lord, the bail was granted, it's a special case because, my lord, 400.
GR case is pending before the learned judge special EC Act come additional district and session judge.
Lordship.
Second court Coach Beer.
Lordship.
Second court Coach Beer.
I'm grateful.
Next.
Lordship, I am for the petitioner. Lordship, the conducting counsel is Mr. Bhaskar Mahashaya. He had to leave Jalpaiguri because of the ailment of her mother. Lordship, kindly fix it on next circuit, Lordship.
On the prayer of the learned advocate for the petitioner, the matter will be listed in the next available circuit.
Well, in this case, it is required.
State is directed to produce the CD on the returnable date. Next.
I don't know 70 and pay for a password. Lordship.
Again, pass over.
Kindly, Lordship.
Pass it over.
Much. Number 18. Item number 18.
I'm for the petitioner, your lordship. May I proceed, your lordship?
Yes, what is this?
Milord, I am challenging the entire proceeding, which was under section 448, 323, 307, 427, and especially with Electricity Act under section 135, 1A. Now, the prosecution case is that, your lordship, at 11th of December 2023, the alleged that the alleged accused person at 2 a.m. at the midnight enter the house of the de facto complainant, and it was alleged that in the FIR that the accused person has hooking up theft of the hooking the electricity with the naked wire and try to electrocution of the de facto complainant. And the case was registered. And by the meantime, your accused person has preferred an anticipatory bail before the division bench of this honorable High Court. In the kindly seeing the annexure, your lordship, annexure P2, page 13. In that order, the anticipatory bail was granted by the division bench with the observation that on perusal the entire material in the case diary, we found no material that substantiate the present victim was alleged in the incident suffered electrocution at the instance of the present accused person. And also, my submission is that, my lord, when a theft of electricity was happened, the complaint has to be lodged by the authorized appropriate authority, appropriate commission, or any other person who has been consent by the appropriate government, your lordship. And it was mentioned in the FIR, your lordship, that the accused person were hooked the electricity by the naked wire. So now my question is, your lordship, how it's possible for a man to touch the naked 440 volt wire, your lordship?
That's
So
why
where
I'm-
is your ground here for this, for quashing? Where is the ground for quashing? You have to demonstrate the prima facie ground for quashing. Otherwise, the CRR cannot be admitted. Otherwise, I have to call for the report from the state. Thereafter, the matter will be admitted. Okay. I call for the city. Okay. Please take down.
Here, my lord, there is an observation of the division bench. that-
Yes, yes. That is up to us of July 2023.
That
Now I want
cannot
the
be a
yes.
ground for.
Very well. Please take down. This is an application for quashing of criminal proceeding arising out of Bhoskadanga Police Station, Coach Bihar. Case number 446. 446 or 466?
446.
446 of 2022 dated 11/12/2022.
Yes, sir, the FIR is written 466. You have written.
What is the correct?
My lord, I arrested P1, my lord.
Yes, FIR is 466.
And
What
then
would
the
be-
bail order also of the High Court is 466. He has mentioned it correction for
You
you.
correct it. Okay, 466 of 2022 dated 11/12/2022 under section 448, 323, 307, 506, 427 of IPC. Read with section 135 within bracket 1 within bracket A of Indian Electricity Act 2003. Now pending before the learned judge, special EC Act. Come additional district and session judge second court, Coach Bihar. Stop. Next, having heard the learned advocate for the petitioner, it appears to me that before admitting the instant appeal, instant criminal revision, the state is required to be heard.
State is unpresent.
Stop. The learned advocate appearing before the state submits that the CD is required for the purpose of hearing of this matter. Let the CD be called for. Stop. List the matter for hearing under the point of admission on the next available circuit. Next.
Number 19.
Your Honor, I'm for the petitioner in this case, sir. Now, this is an application under section 482 of Criminal Procedure Code seeking quashing of a charge sheet being charge sheet number 48 of 2003 dated 31/1/2023 arising out of Siliguri PS 385 of 2023 registered under section 327, 307, 34 and adding section 302 here. My lord, before I go to this case, this is.
Who are you?
I am the petitioner, Your Honor.
Who are the petitioners?
Petitioners, yes, Your Honor.
Who are the petitioners?
Your Honor, I am the wife of the de facto complainant and the daughter-in-law of the deceased. Now, Your Honor, and the petitioner number, other opposite parties are my sister and brother-in-law. My lord.
No. What are you saying? Only one opposite party is there.
No, my lord. Petitioners I'm talking about.
Yes, you are the petitioner.
Petitioner number 1 is the wife of the de facto complainant.
Wife of the de facto complainant.
And 2 and 3, 2 is my sister and 3 is my brother-in-law.
Brother.
Your Honor, and the complainant is opposite party number 2. That is my husband.
Yes.
Your Honor, kindly see this matter has during the investigation, this matter, the de facto complainant had filed a writ petition before this Honorable High Court seeking police inaction, Your Honor. Before I go to the facts, Your Honor, I would like to bring to the notice the orders passed by the coordinate bench under the 226 jurisdiction, Your Honor. Kindly takes up the matter, Your Honor, at page number.
What is the fact of this case? What is the FIR? What is the fact?
I'll state that, Your Honor, because it would come evident from these documents why this case has come before, Your Honor. My lord, at page number 32.
Yes.
My lord, this is an order dated 1/8/2022, filed by the writ petition was filed by the de facto complainant, that is the OP number 2. My lord, kindly see, at the initial days, Your Honor, the court called for the CD. Your Honor, on that date, the CD was called for and the inspector in charge of Siliguri PH was also summoned before this court. Thereafter, Your Honor, at the afternoon hours, the CD was present before this court. Your Honor, and at that time, the petitioners number 2 and 3, who were in anticipatory bail, were directed to assist the police to find the petitioner number 1, who was absconding at that relevant point of time. Your Honor, kindly takes to page number 38. Order dated 2/8/2022. The court says, I have passed an order date on 1/8/2022, whereby the investigating officer was directed to be changed and a sincere officer of the police station was to be given responsibility as an investigating officer. It has already been done and IO has been changed. It is directed that respondent number 6 and 7, that is the petitioner number 2 and 3, to help and assist the investigation. One learned advocate who appeared for respondent number 5 with instructions was recorded on this and as on appearing on this and this on date. So this was the remark. Your Honor, kindly comes to the relevant portion, that is at page 41 onwards, Your Honor. I directed the respondent number 6 and 7 to help and assist the investigation. Learned advocate for the respondent number 6 submits at this juncture that his client helped and assisted the investigating officer. The police report says that 6 and 7 were not present in their house, and it is not understood how the dictatorial situation can be resolved by this court when the petitioners say that they did not help the police and police says the respondent 6 or 7 were not present in their house. I am not ready to disbelieve this police report. Now I direct the respondent number 6 and 7 to extend help to police authorities in finding the respondent number 5. Now, Your Honor, this is on 2nd. After this, Your Honor, the 3rd, the matter was again taken up, Your Honor, and that is very vital, Your Honor, at page 43.
Who is respondent number 5?
My lord, the petitioner number 1 here. We as directed by the court yesterday, the police has filed a report dated this with the effort of the police. Neither Soma Das, that is the petitioner number 2, nor her husband has helping disclosing whereabouts of Rumki Das, that is the petitioner. I have already directed the respondent number 6 and 7 to bring respondent number 5 in courtroom along with her child. And the court has expressed that no order for putting respondent number 5 in custody of the police will be passed by this court. Rather, this court will take a different, positive and sympathetic view in the whole matter. I direct the respondent number 6 and 5 without being apprehensive. On 5th, I was directed to be present before the Honorable Court. Your Honor, thereafter the next page, Your Honor. The 5th, I surrendered before the Honorable Court in the jurisdiction, Your Honor. The respondent number 5 at page number 45, Your Honor. The respondent number 5 has appeared along with the child. I have talked to them. I do not pass any order for taking her in custody. In the endeavor of the judiciary and also the learned advocate for the parties who are the officers of this court to see that they can lead a normal life as husband and wife with a small beautiful child. I am told that respondent number 5 has filed one anticipatory bail application which is pending, which will be taken up on 12th August. I am fixing these matters in my chamber at 10th August 2022 at 4 p.m. when the matter will be heard further in presence of petitioner number 1 and the respondent number 5. That is the de facto complainant and the petitioner number 1 herein. I have directed the petitioner number 1, that is the de facto complainant, to pay an amount of rupees 5,000 as of now to the respondent number 5 immediately, as she has no money in her hand and she is not living in her family under compelling circumstances and she is spending her days with immense difficulties. Your Honor, thereafter, I'll just skip this next paragraph. I have already directed the parents of the child, that is the petitioner number 1 and the respondent number 5, to visit the school of the child on Monday, and ultimately the matter was fixed at chambers here. Now, on 10th/8/2022, the matter was directed to appear before the Honorable Court at chamber, Your Honor, and accordingly it was taken up, Your Honor, at page 48. May I submit?
Yes.
Today, I have heard this matter in my chamber because it relates to some delicate family matter between the husband and wife who started accusing one another in respect of family matter. After ventilating their grievance in presence of their advocates and before me for more than an hour, they have come to their senses at this court has directed to live a peaceful and serene family life with a small and beautiful child of less than 5 years. The child is studying in a reputed school. I am told that compliance of this order, the petitioner and his wife approached the principal of the school, who also took a responsible attitude by saying the parties should not waste their lives with the child and they should settle the dispute which involves criminal allegations made by the husband to the wife immediately and send the child to school. The court appreciates the gesture of the principal of the school. After hearing the parties in presence of the advocate, I find that the stage for narrowing the gap which arose out of misunderstanding between the husband and wife, this court should take a different gesture by sending the parties to a tourist spot for 5 to 6 days through Kolkata. I direct, my lord, there is a schedule of holiday plan that has been directed by the court. Your Honor, thereafter, I am not going to that.
Yes.
I have already requested the concerned department to see the railway tickets and other things are done. Now, Your Honor, let me come to the facts of this case, Your Honor. Your Honor, the de facto complainant lodged a complaint before the police station that I poisoned my mother-in-law with conspiracy with my sister and brother-in-law. This is the entire allegation by the de facto complainant, Your Honor. But in the entire investigation, Your Honor, nowhere, no evidence, not a shred of evidence has been brought in to place me at the crime scene. As per the FIR, Your Honor, let me take Your Honor to the FIR now. Your Honor, it's at page 23. 24, it is the written complaint. Very speculative FIR. With respect, Rajiv Datta, kindly note the date, Your Honor. It is 24/2022, the date of complaint. While the alleged incident is of 11/4/2022. Draw your attention that I got married to the petitioner at her Hindu customs. Then they were born with a child, namely Rajiv Datta. I am reside with my parents, wife and son of aforesaid address since my marriage. Used to torture me in various manner and did not perform marital duty and had no respect towards my parents. Your Honor, very important part, it would be I along with my father at 10 a.m., Your Honor, in the middle. Every day after breakfast at the time, my mother was alone and my aforesaid address and my wife maximum time passed in her elder sister's house, Soma Das, at Pritilata apartment, wherein my mother-in-law and husband of Soma Das also resided. The aforesaid persons also threatened me of putting a 498A case by saying that arrange the fund for residential accommodation of my wife's name of the parents and also quarrel with my married sister Debjani Ghosh and her husband Sushanta Ghosh as they are not able to enter into our house. Ultimately, on 11/4/2022, at around 5/7 p.m., my wife forcibly poured poison in the mouth of my mother to kill her with the conspiracy with the aforesaid persons. Now, this is the allegation, Your Honor. Very important, Your Honor. 5 to 7 p.m., my wife poured poison in the mouth of my mother forcibly with conspiracy. This is the only line that has been put. Thereafter, Your Honor, very important, Your Honor. In the absence of us and thereafter fled our house and took shelter in her sister's house, and my mother called me and my sister Debjani Ghosh through her cell phone number. Your Honor, this number is very important because the call data record would speak otherwise. This is the number of the victim. To our phone call number this and this by saying that she is feeling uneasy because my wife forcibly poured poison in her mouth and fled away from there as a result. I immediately rushed to our house. Now, Your Honor, as he has stated earlier that he goes to his shop at Bidan Market every day. And their house is at College Para, Your Honor. If it is seen, it is merely a 5 minutes walking distance, Your Honor, from Bidan Market to College Para. Now they said it was 5 to 7 p.m. I immediately rushed. This is the version of the complaint. After that, he says, I rushed in our house. At that time, my Didi and Jamai Babu also came there and found my mother. This is also important. According to his FIR, when he reached, after that, his sister and husband of the sister reached. There are several 161 statements, Your Honor, but the de facto complainant has not given any statement again 164. That is a very good point, Your Honor, which they have lapsed. Now, Your Honor, after which a specific case was initiated, the incident is of 11/4/2022. At that point of time, the victim was alive. She succumbed to death much later, Your Honor. Much later, that too in the month of May. Now, my question, Your Honor, the FIR lodged in 11/4/2022 and the death was in the month of May. Around 15 to 20 days, no officer of the police department took the dying declaration of the victim. Surprisingly, maybe she was not able to speak. None of the doctors, she was examined in 3 hospitals, Your Honor. In the Siliguri District Hospital, in the Paramount Hospital, and also after the death, she was taken to NBMCA. Neither of the doctors who attended the victim
Was the charge sheet submitted?
Yes, my lord.
Where is the charge sheet?
It is annexed, Your Honor. Starting at 54. The entire charge sheet is just the replica of the written complaint. No independent investigation has been conducted. Several witnesses has been examined, Your Honor. In totality, there are 14 witnesses. None of them are eyewitnesses who could place me at the time. Everybody has said that Rajiv said that my wife has boat poison. Everybody. None of them have seen that incident. Your Honor, at 5 o'clock, I take my son to
Have you got the copy?
Your Honor,
Copies?
it is supplied.
Copies supplied.
Copy supplied, Your Honor.
Why you not submitted the copies?
I have submitted, Your Honor. The entire documents have submitted.
Where is the copies? Copies of 161 statement?
Everything,
The
Your Honor.
statement of police?
It is continues from page number 54, Your Honor.
Okay. So why you are here? For quashing?
Quashing, Your Honor, because this is a completely false and frivolous case. Your Honor, my mother has written a note that she is committing suicide. Why? Because my husband is having an affair with my own aunt.
Where is the statement?
Your Honor.
Where is the statement?
Which statement?
The statement of mother?
Mother's statement is not taken, Your Honor.
So where
there is a note, Your Honor. I have submitted. Yes.
Where is the note?
I have annexed it, Your Honor. Your Honor, kindly takes page number 107 onwards, Your Honor. This is my forwarding letter to the investigating officer, Your Honor, dated 25/2022. Thereafter, Your Honor, will see a letter dated 19/5/2022 at page number 108. My lord has found it. 108. It is a letter addressed to the inspector in charge of Siliguri police station and the investigating officer at that point.
Yes, your letter.
Yes, Your Honor. I, Runkidas Datto, so and so. Do you
I understand your letter is there.
Your Honor, kindly see what I have written. State that in reference to the officer, the investigating officer had conducted search /raid in my matrimonial house at around 5 p.m. on 25/4/2022, and I was present at the time during the search or raid. And I requested you to seize the handwritten note of my mother-in-law, which she had written prior to her death, but due to reasons unknown to the IO, did not seize the said written note and signed by my deceased mother-in-law. My advocate even contacted you over phone and tried to meet you with addressee number 2, but on different context you denied. I
know the law entirely.
Yes,
So
sir.
whether this can be challenged in the quashing application?
My lord, I am not trying to challenge only on the basis of this document, Your Honor. Kindly look into the investigation that has been carried on by the investigating agency. What has been written, it has to be investigated independently. Kindly see the materials in the charge sheet, my lord.
Where you? This is the motion stage. I cannot go to the hearing.
Your Honor, let me submit and I would satisfy this court that there is no.
No, this is not the stage of hearing.
I know, Your Honor, but at least a stay. That I'm
No,
pleading
stay,
because it is
I
an
don't think any-
unnecessarily troubling me. To
I
go to
don't
the
think
court.
any material of stay here.
My lord, these materials will be evident, my lord, the court in a writ jurisdiction.
I'm giving you, in the writ jurisdiction, what happened?
They sought
What
the
happened?
police inaction, Your Honor.
No, what happened in the writ jurisdiction ultimately? The court tried to minimize the dispute. It was not minimized. This is the only purpose.
But my lord,
The writ
why did
jurisdiction.
the court take that endeavor? If I was an accused of such a heinous crime, would the court have taken such a view?
Whatever may be, what is the effect? What is the effect of the writ jurisdiction?
No, madam,
In this matter?
I'm not saying that would affect this because that is an independent separate proceeding. But
Whatever
even
may
it
be
has
the
an-
proceeding,
My lord-
ultimately it was not culminated to the compromise.
My lord, it was a police inaction case. They sought
Police
for
in
my
action
arrest.
case, yes, you have come with the police in action case. Thereafter, you have challenged the.
I did not go for police inaction, my lord. It was the de facto complaint.
Very well. No, that proceeding cannot be looked into here.
No, I'm not. Let me place the charge sheet in totality. my lord.
You come with the hearing.
Your Honor, kindly see, my only humble submission is the sessions case has been initiated. In the meantime, I will be prejudiced, my lord, if I have to go to both the forums. Still, this is disposed. Kindly give me a limited stay. I have approached this court with clean hands. I have nothing to hide, my lord. There is nothing, not a single evidence that would connect me to the alleged incidents, except the statement made by the de facto complainant, which itself is contradictory. That I can show from the 161 and 164 statements.
This is an application under section 482 of the Code of Criminal Procedure for quashing sessions case number 1 of 2024 pending before the learned additional session judge. First track court at Siliguri in connection with Siliguri PS charge sheet number 48 of 2023 dated 31 January 2023 arising out of Siliguri PS case number 385 of 2022 dated 24/2022. Under section
Your Honor, 302 was added later on.
328, 307, 34 with adding section 302 IPC. Stop. Learned advocate, the petitioner submits that the present petitioners is the present petitioner number 1 is the wife of the opposite party number 2, and present petitioner number 2 and 3 are the sister and brother of the petitioner number 1. Stop. There are matrimonial disputes between the petitioner number 1 and the opposite party number 2. And the mother of the opposite party number 2 died due to some unnatural circumstances. Accordingly, the present petitioners were falsely implicated in the alleged offence. He further submits that by virtue of writ jurisdiction before this honorable court, the entire dispute between the parties were taken for solution, taken to minimize to their disputes, but the same exercise became futile. Stop. He further submits that the investigation of the police is ended in charge sheet, and the charge sheet will reflect that the investigation of the investigating agency is perfunctory. He further submits that there are some merits.
There is delay in lodging FIR also.
There are some merits to by which the entire criminal proceedings is liable to be quashed. Having heard the learned advocate for the petitioner and after perusing the petition itself along with the annexures thereof, I find it appears to me that the petitioner has demonstrated an arguable case before this court. Accordingly, the instant criminal division be admitted. Stop. The petition is directed to serve the copy of petition along with the annexures thereof to the opposite parties and file an affidavit of service on the returnable date. Let the matter appear in the appear under the heading of hearing in the ensuing circuit bench for the month of June 2024. Stop. Considering the facts and circumstances of this case, the further proceedings of the sessions case number 1 of 2024 pending before the London Additional Session Judge, First Track Court, Siliguri, be stayed till 28 June of 2024 or until further whichever is earlier.
Deeply obliged.
Next.
Item number 20.
I'm for the petitioner, Lordship.
So the issue involved is this, Lordship, over a self-same cause of action, two FIR has been registered. One is by the de facto complainant. Here is the opposite party number 2. Another is the petitioner himself. Lordship, the occurrence was of 10th of July 2023, where the de facto complaint means the opposite party number 2 has lodged a complaint against the petitioner and other accused person, and thereafter on the there is a different version of the entire prosecution case. That's why the petitioner has also lodged a complaint that has also been registered as a police case. So I have annexed both the FIRs. What happened, Lordship, subsequently the investigation was carried out in both the cases. Lordship, I had also made a representation to the investigating officer concerned by disclosing and communicating the sterling quality of evidences to the first to the impugned proceeding, to the impugned FIR, where by which I have established that this is the original version. You can take cognizance of an investigation of with regard to the sterling witness. That has not been considered even. Neither the my FIR has been registered. My FIR has intangibly been investigated, not the first one also. So in this court, I have also taken. I have been given bail. I am also on bail. The other accused person who are also accused person in the impugned proceeding are on bail. There is no other proceeding against the case against the petitioner, Lordship. In this court, Lordship, I challenge the first FIR on the ground that both the cases should be investigated by the common investigator for common investigation and joint trial. Because the one incident cannot be, the law is this, logic is this, that one incident cannot be dual version. Either the first version will be correct or the second version will be correct. Which one is correct is to be investigated by the common investigating officer, not by two different investigation officers. This is the law. On this particular prima facie ground, I have challenged this, Lordship. Since this is my case, Lordship, I am paying for interim order.
What is the stage?
Both the cases are purportedly investigated, still pending investigation.
Pending investigation.
Yes, that too also since July 2023.
Okay, call for the report.
That report will also my impugned order.
What is the purpose of stay?
Because what happened, Lordship? Because the election is going on 19th of July, the date of casting of vote has been fixed. The petitioner is also a political figure. And
any order of coercive action cannot be, that can be passed.
Yes, yes.
Stay of the proceeding cannot be there.
Yes.
Okay.
It can be, sir.
This is please take down. This is an application for quashing the impugned proceeding being general registered case number. GR case number 377 of 2023 arising out of Dinhata Police Station case number 363 of 2023 dated 10/7/2023 under section 341, 323, 325, 186, 188, 353, 323, 307, 34 IPC, read with section 25/27 of Arms Act 1959. Now pending before the learned Additional Chief Judicial Magistrate Dinhata, Coach Bihar. Stop. Learned advocate to the petitioner submits that there are case and counter case between the there are two cases, two complaints lodged by the present petitioner as well as the opposite parties due to the political rivalry between the parties. Stop. The investigation of the both complaint need be conducted by the same investigating agency. However, the police is not conducting the investigation of the complaint lodged by the present petitioner properly,
It has been registered
though it has been registered.
as the Dinata Police Station case number 392 of 2023.
Though it has been registered
As
by
390
Dinata Police Station case number 392.
Yes,
392
of 2023,
2023, dated
dated, Lordship, 19th of July, 2023.
19th of July 2023.
Yes.
Full stop. Having heard the learned advocate for the petitioners, it appears to me that before passing any appropriate order, the state is required to be heard. Accordingly, call for the report from the state. The petition is directed to serve the copy of petition along with the annexes thereof upon the state and file an affidavit of service on the returnable date. Stop. During the next one, concerning the facts and circumstances of this case, the investigating agency is directed not to take any coercive steps against the present petitioner till 28th day of June 2024 or until further order, whichever is out. Let the matter fixed under the heading of hearing in the ensuing circuit bench for the month of June 2024.
Grateful, Lordship. Lordship, may I, one request, Lordship, my item is 52 also. This is a motion, Lordship. Lordship, can it be taken up because I have a return ticket, Lordship, by 2 o'clock. I have to return it.
What is that matter 52?
A short matter, Lordship. Only custody battle is going on, Lordship. My interim prayer has been deferred for a long period of time. That need to be.
52 is the civil motion.
Yes, civil motion. Not admitted, Lordship. The first hearing, first motion. It can be taken up now, Lordship.
No.
Lordship, because I have a return, I have to return, Lordship. My train is 2 o'clock, Lordship. That's why I'm requesting. Only.
There are several advocates.
No, Lordship, but still, many are interested to do their matter. Many are not interested.
All are interested to do the matters.
Lordship,
how can I jump?
Lordship, this is not a contested motion, Lordship. Only 1 minute requires, Lordship. Very short issue. Very short issue.
What is the issue here?
Issue is this is my interim application for modification of prayer for custody of my child has been deferred hearing for long period of time. It requires to be intervened by this honorable court directing that my application for interim prayer for custody of my child can be heard out at the earliest, but preponing the date. This is the humble prayer. Other side, it need not to be heard out because the preponement of date.
Okay, give me the item number 52.
52.
Where is it pending?
Lordship, Alipurduar.
Alipur.
Yes.
Alipurduar.
Alipurduar. Yes.
Learned district judge Alipurduar.
Yes. So, in a strange matrimonial relationship, section 9 of the section 9 application, yes, 52. The issue is this, Lordship, in section 9 application filed by the husband is pending before the learned district judge under section 9 of the Hindu Marriage Act, where the husband has paid for a interim custody under section 26 of the child. Lordship, the interim custody was allowed by an order dated 11th of October 2023. When the order was attempted to comply with, by seeing the child, he was denied. That's why a modification prayer has been taken out before the same court by this petitioner. This modification application is still pending. Kindly see the I have taken out the modification application, and this is it is recorded in page number by an order dated 17th of July 17th of October 2023. The impugned order, the certified copy of the order. Can you see? 17th of October 2023. You got it? wherein it has been stated that the record is put up on the prayer of the petitioner, of the lawyer on behalf of the petitioner, lawyer prayer for modification order dated 11th of October 2023. The prayer for petition is kept with the record. It has been made, it is, I don't know how it has been kept with the record, and there is no, and there is a date was fixed for 6th of December 2023 for.
What is the order of 6th of December?
6th of December on the next day, next page. There is no order because 6th of December there was a court was not functioning due to some
order?
So order has not been given. This is the subsequently.
No, where is the 6th of order of 6th December?
6th.
You have annexed 15th January's order.
No,
if it was not put on 6th of December, the next order would be on 7th of December.
Definitely, but
where is the order?
Nothing was said, Lordship. That's why the subsequent order has been.
No, I think the order has been passed.
No, Lordship. I have.
Then where is the order?
I have avoided, Lordship. I'm showing.
Where is the order? If the record is not put up for the holiday, then the matter will be next on the next day.
On 15th of January?
No.
15th
The
of
matter
January.
was fixed for hearing.
Yes.
How the matter is appear for the issue?
Exactly. This is the thing. The matter. Then the main application for issuance of the issue has been posted for framing of issue. My modification application have gone away. I'm praying only this modification application first need to be heard out. This is the intervention that this only intervention is required from this honorable court prior to framing of the issue. Next date is fixed on the 13th of June.
I have to heard the learned advocate for the opposite party.
I'm not praying for any stay, nothing else. I'm only disposal, directing that my modification application.
No, I have to heard the opposite party. You serve and come. Please take down. The instant CO has been preferred by the present petitioner, wherein his prayer for modification was not heard by the learned district judge, learned additional district judge Alipurduar in
17th of
in Matsud number 335 of 2023.
Yes.
Stop. He submits that the date for hearing of the modification application filed by the present petitioner was fixed on 6/12/2023. Thereafter, 23, thereafter, no date was fixed for hearing of that petition. Stop. Having heard the learned advocate for the petitioner is directed to serve the copy of the CO along with the annexes thereof to the opposite party and file an affidavit service on the return. Let the matter appears
next side
in the next available circuit.
Grateful.
Lordship, I am for the petitioner, praying for not today, Lordship.
Not this week. Next available circuit.
Lordship, I am appearing on behalf of the petitioner, Lordship. Lordship, this is a prayer for quashing of the entire proceedings as well as of the charge sheet. Lordship, previously it was heard, your Lordship has heard it on Thursday, but because my prayer was not correct, your Lordship has given me the liberty to come once again. Now, Lordship, if I may, in this case, Lordship, the matter pertains, it emanates from a non-refunding or from a belief of the de facto complainant that 1800 rupees of non-refunding, from there the matter has originated. The gist fact of the case, Lordship, if I may, is that the de facto complainant had given 1800 rupees to a company and believing that she has been cheated, the company had taken that 1800 rupees on the pretext of giving her a job or giving her the connection of a job opportunity. And believing that she has been cheated, she has filed this complaint. The complaint was filed on 24th of July 2021. Thereafter, on the next date, 25th of 7th, 2021, this petitioner was granted bail by the learned ACJM Siliguri. Thereafter, Lordship, on 25th of January 2024, the charge sheet of the case was, the charge sheet was placed before the learned ACGM Shiliguri, and the learned ACGM Shiliguri has taken cognizance. Thereafter, on that day, it was transferred to the JM second Shiliguri. Now, Lordship, I am praying for quashing of the entire proceedings as well as of the charge sheet. Now, Lordship, if I may, in this regard, I am referring to a judgment passed by the Honorable Madras High Court. Lordship, this is Shanmugam versus the Inspector of Police. In this case, Lordship, my case, Lordship, if I may, is that the cognizance that was taken by the learned JM Second Shiliguri, it was taken in a rubber stamp manner. And on that ground, this case is, I believe, to be fitting one. Lordship, in this case, the Honorable Madras High Court, based on a Supreme Court judgment, has depreciated the practice of taking rubber stamp cognizances. Lordship, in this case, the relevant paragraphs, if I may. The first one is, Lordship, in this case, amongst the many grounds, one of the grounds on which the proceeding of the entire case was quashed was because of the rubber stamp proceedings that was rubber stamp cognizance that was taken. First, your Lordship kindly comes to firstly to paragraph number 21 and then to 22. The 21, the Honorable Supreme Court in Sunil Bharti Mittal versus Central Bureau of Investigation reported in this part it is quoted as the context of the Supreme Court judgment is quoted.
In this case, the magistrate has taken cognizance on the basis of a charge sheet.
Yes, Lordship, on the basis of the charge sheet.
Why you are submitting that this is the rubber stamp?
No, Lordship, that is what I am, because Lordship, if I may, it is 18, the matter pertains from meager amount of 1800 rupees. Also, Lordship, on that relevant point of time, the matter is that I was not even present at that position, Lordship. My name has been subsequently inducted in the FIR. I did go to the police station and
whether that can be looked into by the magistrate at the taking cognizance at the time on the basis of the charge sheet.
No, Lordship.
Then that has to be given to the trial, whether you are there or not.
Lordship, also on one of the other grounds, amongst the other grounds, which I am praying for quashing of this proceeding, is because, Lordship, I am a student. At that point of time, I was a student back that time. At that point of time, I was working with this organization just to meet my educational expenses. That time, I was a first year or a second year college student. Even today, I am a student. I have been studying in MBA. Lordship kindly comes to the annexures of my petitions. I have annexed those, my educational qualifications, the final year mark sheet from NBU, the certificate of graduation, my mark sheet from the MBA course that I am pursuing. Lordship, all have been annexed. All I am praying for is the Lordship for kindly quash the proceedings and the charge sheet, because, Lordship, to my mind and my belief that this is a rubber stamp proceedings, it emanates specifically from a meager amount of 1800.
1800 is not the meager amount on your view. It certainly meager amount. But 10 rupees is also not meager amount.
It shouldn't have happened
to any person.
Lordship, it shouldn't have happened. I do agree, but Lordship, but I was not involved in this offence, Lordship, in any way. On the first day itself, I was granted bail by the learned ACGM, Lordship.
So what you want now in the
Lordship? I am praying for quashing of the proceedings based on this Madras High Court judgment, Lordship. Shanmugam versus Inspector of Police.
It cannot be quashed at this stage without hearing the other parties, you know.
My lord, I'm for the state, my lord. Mayor, the amount he has stated that 1800 is not a intention is that the criminal means we abide. But it is 1800 or 18,000 or 18 lakhs is not the question.
Yes.
And regarding there is no ground for quashing. And second is already the court has taken cognizance at the time of hearing of the charge. This matter can be, these points can be considered. And moreover, he might have a very good academic career, my lord.
Whether charge has been framed?
No, charge has not.
Charge has not been framed.
Lordship, the charge.
We have the option to challenge the charge.
No, Lordship, the charge hearing is fixed as late as September of 2024. That is one of the grounds why also this petition was.
I can direct to conduct the charge hearing as early as possible. You can file a discharge application there. You have the every opportunity. You have got the copies. Copy has been served.
Yes, Lordship, the copies has been served, Lordship.
You can challenge the charge.
Lordship, but it is fixed as late as September 2024, Lordship.
September
of the
that can be flipped on.
That can I direct to you as your wish.
Yes, Lordship, but then what happens, if I may? At that time, if the learned James II refuses to entertain my discharge petition,
Then you
again
can
I
come.
have to come here,
Yes,
Lordship.
you have
It
to
will be
come, you
a
can
very
come.
long due process, Lordship.
No, no.
So, Lordship, if I may,
You
kindly,
have the options. If you challenge this here, you may have the opportunity there also.
no, that is certainly the case, Lordship. But then what I'm submitting, Lordship, is that if the learned James II or the learned trial court below refuses to entertain my petition, I'll again have to come here, Lordship. It will be a very long drawn process. All I'm saying, Lordship, I was not in any way
Very well.
engaged with this
You
office,
want to,
Lordship.
you want to proceed with this charge, with this CRR, very well.
Lordship,
I
I'm
think
paying
no
for
stay is
the
required. No stay is required. The date is fixed on September, I think.
No, Lordship, I have
Prior to
paid
that,
for
it would be heard.
Lordship.
This matter. I am
My
fixing
lord,
the date
my
of
lord has
hearing.
given a very good option to you. So let it be preponed and let there be, otherwise if it is rejected here, then it will be an adverse order on the part of the honorable.
Lordship, in that
I
case,
keep it
Lordship,
pending and giving you a specific direction to.
Lordship, if I may, Lordship, may it be preponed in this month itself, possibly?
No, this month cannot be done like that. It may be the.
Next month, Lordship.
Next month or like.
That.
May, Lordship, may it will be extremely helpful, Lordship.
Okay. Please take down. The instant CRR has been preferred for quashing the proceeding, being GR case number 3259 of 2021, arising out of Siliguri Police Station case number 881 of 2021, dated 24/7/2021, under section 420, 406, 120B IPC, wherein the charge sheet has been submitted against the present petition, now pending before the learned judicial magistrate, second court, Siliguri. Stop. Learned advocate for the petitioner submits that he has been served with the copies by the investigating agent from the court. Stop. From the court of learned magistrate. Stop.
Lordship, if I may, one intelligence, Lordship. It is not ascertained whether the copies have been served or not. That I have to take instruction. I'm sorry, in flow I submitted the wrong thing, Lordship. It is not clear yet.
It has been served, that's why it's.
No, I don't have instructions to that regard.
Okay, very well. Well, stop. He further submits that the charge sheet has been submitted by the police, and on the basis of the charge sheet, the London magistrate had taken cognizance of the offence. Stop. He further submits that the hearing of the charge was fixed by the London magistrate for the month of September 2024. He prayed that his prayer for prayed that that the charge hearing may be preponed. Till then, the instant CRR may be kept pending. Stop. Learned advocate appearing on behalf of the state submits that the matter can be kept pending till the disposal of the charge hearing.
Can be disposed of. If they, after charge hearing, if there is an application, they can file it for it. Otherwise, they have to amend this.
Yes.
Difficult. It can be disposed of.
Yes. কি বললাম?
Learned advocate appearing on the state submits that the matter can be kept pending till the disposal of the charge.
No, and for the state submits that the no purpose would be served for keeping pending of the instant CRR until hearing of the charge before the learned magistrate. Stop. At the learned advocate, it appears that the present petitioner has every opportunity to challenge the charge sheet before the learned magistrate by filing a specific applications. The copies of the available copies of the statement and the materials collected by the investigating agency must have served upon the opposite parties before hearing of the charge application. Stop. Considering the fact, I think it necessary that if the instant CRR be heard on merit it would be incumbent upon the learned magistrate to carry out the charge hearing. Accordingly, the instance here is disposed of without any specific observation regarding the merit of this matter. Stop. The petitioner is at liberty to file an appropriate application against the appropriate application for discharge before the learned magistrate. Stop. On such application, the learned magistrate shall hear out the parties and pass an appropriate order according to the law on the basis of the available materials collected by the investigating agents. According to the instance here is disposed of. Let the learned magistrate be prepone the charge hearing of this matter in the month of May 2024.
Lordship, one indulgence, Lordship, can it be prayed that upon the filing of a put-up petition before the learned James II, can be,
You just annex this order by filing a application. Already the matter would be okay.
all right?
You annex this order
Yes.
with an application before the learned magistrate. The matter would be already preponed.
No, Lordship, I was praying for on any day, then I can go before the learned lower court on any without specifying
I am
any date.
fixing on the May.
Okay.
May. Before May, it would not possible for the magistrate to take out the matter. You know.
All right, Lordship, all right, Lordship.
Next.
Item number 23. Item number 23. Mr. Shubham, I think council member mentioned by him yesterday, conclusion Friday, is out of session, that's why he is mentioning.
Not today. Very good. Not today.
Item number 24.
24 Millard is my application. It's appearing for the first time. Millard, a very short question of law, Millard, is involved. As regards, Millard, whether in a proceeding under the West Bengal Shop and Establishments Act, at the first instance, where the inspection has been conducted in a factory having a designated general manager, whether instead of implicating him as a accused person in the summons, whether the summons can be directed against the managing director. This is not only the short question which is involved. Now, Millard, I am covered with a judgment of the Supreme Court. If Millard takes the West Bengal Shop and Establishments Act once. If Millard kindly takes Millard section 2, subsection 4, that is Millard the definition of employer. Millard, if I just read out Millard, employer means a person owning or having charge of an establishment and includes an agent or a manager of, and this and Millard is very important, and any other person acting on behalf of such person in the general management or control of such establishment. Now, Millard, a similar provision is contained, Millard, under the Minimum Wages Act also. In that context, section 22C, capital C, the Supreme Court, Millard, has delivered a very recent judgment and very detailed one, saying that the conducting inspecting officer has to ascertain as to the person who was actually in charge of the establishment, instead of vicariously shifting the liability to the director, managing director, any member of the board instead. Millard, if I may just place the judgment also for your lordship's consideration once. Let me come to paragraph 10.
Regarding the vicarious liability.
Regarding vicarious liability. Now, Millard, my contention here.
What has happened here?
Millard, here what has happened is, Millard, an inspection has been conducted in a factory, admittedly, no difficulty. The factory has a designated general manager who was present at the time of inspection, who is in charge of the day-to-day affairs of the factory. Instead of directing the summons to him, what the officer has done here has intentionally, I would say intentionally,
directed it against the managing director of the company, who doesn't stay in the factory, whose office is situated miles apart from the factory, nothing to do with general day-to-day business. Now, Millard would see, kindly see, Millard, the inspections.
Where is the report of the inspection?
Yes, Millard, I'll just place. Millard, Millard comes to Millard in the certified copy. Millard, it is not, certified copy is not paginated. Millard would find the inspection report which has been submitted before the additional Chief Judicial Magistrate Siliguri. Millard,
Annexure 2.
Yes, yes, yes. After the order sheet.
Yes.
After the order sheet, the next page.
Yes.
Most respectfully, Shwet, Millard would find in the middle of the page. That is Millard, the observation of the inspecting officer. Mr. So and so are the employer within the meaning of section 2(4) of the West Bengal Shop and Establishments Act and rules. Thereunder, in respect of the employment of owned him/them under the name and style of so and the address. That the aforesaid employment is the scheduled employment and covered under the Shops and Establishments Act. That the petitioners visited the said employment and detected the following infringement. That is all right. No difficulty, we will contest it. But the only question is whether this complaint against the managing director, who has nothing to do in the day-to-day affairs of the factory, and when the factory admittedly had a general manager in place who was present at the time of inspection, whether this summons against him is maintainable or not.
Okay, okay, understand. Okay, please take down. The instant CRR has been preferred for quashing the proceeding of complaint case number 606 of 2018 under section 21 within brackets 1 of West Bengal Shop and Establishment Act 1963 pending before the learned Judicial Magistrate Third Court at Siliguri. Stop. The learned advocate for the petitioner submits that the petitioner is the managing director of the Terai Tea Company Limited and was not involved or responsible for day-to-day affairs of the said tea company.
Factory, Millard. The tea
Factory of the tea company situated at
Khoribari.
At Khoribari under PS?
PS Khoribari.
Under PS Khoribari. Stop. He further submits that the present petitioner is not vicariously liable for any alleged criminal offense or activity conducted at the said factory premises. Stop. Having heard the learned advocate for the petitioner, it appears to me that the present petitioner has demonstrated a good arguable case before this court. Accordingly, the CRR be admitted. Stop. The petitioner is directed to serve the copy of petition along with the annexes thereof to the opposite party and file an affidavit of service on the returnable date. Stop. Considering the facts and circumstances of this case, there shall be an order of stay of the operation of the.
If Millard stays the proceedings for the time being, Millard, instead of the last order, Millard, the proceedings.
Of the proceedings of further proceeding, stay the. Of the proceeding, further proceedings, the further proceeding of complaint case number 606 of 2018, pending before the learned Judicial Third Court Siliguri till 28th day of June 2024 or until further or whichever is earlier. Let the matter appear for hearing under the in the next time civil circuit for the month of June 2024.
Grateful, Millard. Millard, if I may take back the judgment. Millard, if I may take back the judgment.
Yes.
Great. Actually, Xerox, readings.
Item number 25.
চলে ভালো না
Yes, Lordship, in this matter, interim relief was granted on 13/10/2023. I had ordered it at 13/10/2023 and it
Order
was
dated
13/10/2023.
I got the opposite party number, so copy has not been served.
copy has not been served.
On the last occasion,
Copy of the Milad,
I'm holding a copy of the CAN application.
No, copy of CRAN application as well as the entire
CRR has been served.
CRR has been served.
Yeah, it has been served.
Okay. So the matter is otherwise ready for hearing. I can fix the date for hearing.
You can fix the date for you. In the meantime, I'm praying for a short stay of that.
What is the CRAN number?
1.
Heading CRAN 1 of 2023. This is an application for extension of interim order passed by this court on when it was passed interim order
13/10/2023.
13th of October 2023. Stop. Heard the learned advocate for petition. Also heard the learned advocate for the opposite party. Considering the fact the interim order was passed on merit, so I intend to.
the expired not 15/23. Interim order was passed on mail, so I intend to
Extend the interim order by fixing a date of hearing of this matter. Accordingly, the CRAN 1 of 2023 is disposed of with a direction that accordingly take a para debe. Accordingly, the CRAN 1 of 2023 is disposed of with a direction that the interim order passed by this court on the earlier occasion be further extended till 24th of May 2024 or until further order, whichever is earlier. Stop. Let the matter appear under the heading of hearing in the next ensuing circuit. CRAN 1 of 2024 is disposed of. Next Friday. Yes. निपेन तुम्हें जाओ कोरोना में ऊपर भी आस्ते आस्ते जाते
Item number 26.
Madam, I'm for the petitioner. Madam, affidavit of service I have served. Madam, order for stay of 6 weeks was passed on 23rd February 2024. I have filed this application for extension of the stay already granted. I pray the stay order may be extended till disposal of the divisional application.
Yes, which for the opposite party?
Lakshit.
No one is appearing.
Lakshit.
Please take down. Heading karo CRAN 1 of 2024. Underline karo da order heading. Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. Decision application for extension of interim order passed by this court on 23rd of February 2024. Stop. Heard the learned advocate for the petitioner. Stop. None appears on behalf of the opposite party. Stop. Next paragraph. Having heard the learned advocate for the petitioner, the CRAN 1 of 2024 is disposed of with a direction that the interim order passed by this court on the earlier occasion is further extended till June 28, 2024 or until further order, whichever is earlier. Let the matter appear in the list under the heading of hearing, under the heading of hearing in the month of June 2024.
Grateful, your lordship.
And 1 of 2024 is disposed.
My lord, Mr. Pathrapratim Sarkar is the conducting advocate in this matter. His father is suddenly developed high fever. That's why it cannot able to come to the court. Please make it on.
Next circuit.
But I am for the state.
Next circuit. Next.
I am appearing for the appellant's lordship.
Yes.
This is an application.
No, next circuit.
This is an application for bail in connection with appeal. 28. Service fee.
Have you served the CRAN 1?
Yes, lordship.
File an affidavit of service then.
Lordship.
State has to be heard. Who is the state?
Bail in connection with appeal, lordships.
Whatever may be, state has to be heard. We are moving an application for bail.
Yes. Conviction is under section 363 and 366A, lordship.
5 years.
It was for 7 years. And the two of the appellants, lordship. And during trial, they are all along on bail.
Since when they are in custody?
Lordship, they are in custody since 17th of February 2024.
17th of February 2024. Yes.
Cases of 2008, lordship, the conviction is 2024. And during trial, all along they are on bail, lordship.
What is your submission?
My lord,
on any condition, lordship.
Regarding the bail, it's up to my lord, but there must be a direction that later on, because what happens after the bail, my lord, it is very difficult to conduct the hearing of the appeal.
No,
they should not take any unnecessary, my lord.
Appeal is requirement for the advocates, not the requirements for the parties.
No, the hearing must be
Is
done.
there any adverse report regarding conducting trial or like that?
As per his statement, he is stating that in all the occasions.
Or on bail?
No, they have not jumped the bail.
There is no adverse report like that. Okay, please take down. Then 1 of 2024. This is an application for bail by the appellant.
Appellants, lordship.
Appellants. By the appellants arising out of CRA within bracket SB number 3 of 2024. Stop. The learned advocate for the petitioner. Next part, the learned advocate. প্রত্যেকটা sentence পড়ে তারা করে। The learned advocate for the petitioner stroke appellant submits that the present appellant was convicted by judgment and order dated 17th February 2024. 17th February 2024. Passed by the learned additional district and session judge, Fourth Court Jalpaiguri, in connection with sessions case number 254 of 2015, arising out of Kotwali PS case number 530 of 2008, dated 27/3/2008, under section 363 of stroke 366A capital of Indian Penal Code. Thereby, the present appellants were convicted and sentenced to suffer simple imprisonment for 5 years with fine of rupees 1,000 each for an offence punishable under section 366 of IPC, and also sentenced to suffer simple imprisonment for a
363 5 years and 366A
yes
7 years.
কি বললাম বলো
For an offense punishable under section 366 of IPC and also sentenced to suffer simple
imprisonment for a term of 7 years each, and also to pay fine of rupees 2,000 each, IDSI for 1 month each, for the offence punishable under section 366A of IPC. Stop. Learned advocate, next paragraph. Learned advocate for the petitioner submits that the present petitioners are in custody since 17th February.
17th February.
17th February 2024. And it would be revealed that they were all along on bail during the entire trial and never misappropriate their liberty. Stop. Next paragraph. Learned advocate for the state raised strong objection. Are the learned advocates? Where is the materials on record? Next paragraph. As it appears that the present appellant petitioners are all along on bail during the entire criminal trial, the entire trial before the learned session judge. So I think it necessary that they are entitled to have a favorable order. Stop. Next paragraph. The present petitioners, namely such and such, নামগুলো লিখবে দেখে ভুল করো নামগুলো, ভুল হয়ে যাবে। petitioner নামগুলো লেখা আছে petitioner যেটা আছে না, এটার উপর এই নাম লেখা আছে, নামগুলো আলাইজ ফেলাইজ সব লিখবে, ঠিক আছে? এই সনদটা লেখার দরকার নেই, শুধু নামটা লিখবে, ঠিক আছে? কি বলা? The present petitioners, namely such and such, may find bail of rupees 10,000, bail of rupees 10,000 with 2 registered security, each one of whom must be local, 2 registered security for a level of like amount, 2 registered securities of like amount, one of whom must be local. Subject to satisfaction of learned
Lordship, CGM Jalpaiguri.
CGM Jalpaiguri. Accordingly, the instant grant one of
Instead of 10,000, let me 5,000, should have four.
all are poor. We are also poor.
According to the ancient trend,
Then
Declare.
1 of 2024 is disposed.
Declare.
No password. I will proceed with the list.
What matter was passed by your lordship?
All password, there are several password matter. If I take the password matter, then no matter will be taken up today. Call, proceed.
My lord, same conducting advocate, my lord.
Okay, next available circuit. Next.
Lordship, our senior Sabir Ahmed is in virtual mode, Lordship.
No one is appearing. Next. Pass it over.
My lord, I'm appearing, my lord. My lord, I'm appearing, my lord.
Okay.
Lord, hopefully I have reached the pass, my lord.
Yes, now you are audible. What is this? This is hearing.
We appear for the opposite party, my lord.
Who is for the petitioner? You are on behalf of the opposite party.
Saurav Ganguly was appearing for the. Yes, my lord.
I'm appearing in 31.
This is
In board it is mentioned 30.
This is item number 30.
Oh, my lord, I am in the next matter, my lord.
Okay. Pass over. Next circuit. Item number 31.
31. This is a state revision, lordship. Lordship knows that previously I have argued that the learned PP will appear in this matter. I have already contacted and the case diary is not available at present. So kindly make it next circuit. He will come and do the matter.
Okay, next circuit. On the prayer of for the state. On the prayer on advocate for the state, the matter be attended today. Let the matter be placed in the next circuit. Next.
32. 32.
Pass it over for the day.
$33.
33 I'm for the revision, His Lordship.
Lord, I appear for the opposite party number 2 here.
This is a matter of hearing.
Matter of hearing, Lordship.
Can it be concluded?
It will be almost.
No, Lord, Lord, I feel like this will be concluded, but Mr. Ganguly is not eager to, Lord,
so what
do the matter? Since, Lord, this is a case, Lord, complaint case, prima facie case is made out based on the report filed by the, Lord, police authority. But there is a direction passed by this by Lord Magistrate to cause an inquiry. The inquiry report reveals that there is a prima facie case to proceed. I don't know.
Okay, very
No, I am very much eager to do the matter as because the police report mentioning the date when the incident took place, I'll show from their documents no such incident took place on that very day.
Very well. I am fixing next circuit for the hearing. Please take down.
I'm ready with this, sir.
Let the matter be fixed under the heading of on the first day of next appellate circuit.
Grateful, Lordship.
The first day of next appellate circuit. Yes. Lordship. Next.
My lord, I appear for the opposite party number 2 and 4. I've concluded my submission yesterday, my lord.
Lordship, I am for the petition. Yes. Lordship, may I proceed? Yes. Lordship, my learned friend has referred for judgment before your lordship. Four. Yes. The cases, all the four cases are different from the facts and scenario of the instant case. In all the cases, FIR was lost by a competent authority. And thereafter, whether the prima facie case will come up or not, it is being considered. Yes. Now, in case Rajiv Kaurav versus Vaishnav, the only thing, if the prima facie case is established, then court cannot interfere into the aspect. In Shaukamal Shivji Paranekar versus State of Maharashtra, it's issuing a process under section 156(3) of the complaint. Next one is Muhammad Alauddin Khan versus State of Bihar. Yes. In this case, the question was that if the civil case is pending, criminal liability would not be absorbed. Next one, it's a case on FCRA. It's a complete different fact. Now, our FIR, whether from the FIR itself, any prima facie case is at all established, that is to be looked into. And this FIR is practically led by a backstory, that is the story which was posed by the private respondents before the executive magistrate. And then the interim order was passed. That interim order has already been set aside by the coordinated bench of Honorable Court. So this is one aspect. And next aspect is the person who has lost the FIR, he is not the competent person. But in all other cases, those which are referred are something completely different. May I refer
The CBI case, that is CBI versus Aravind Khanna, my learned friend referred para 19.
Yes, 19 and 20.
19 and 20. Several, in para 19, if we go through the para, then it will reveal several disputed facts were considered by the Honorable High Court, and thereafter matter went to the Supreme Court. And wherein Honorable Apex Court has observed that disputed fact cannot be considered at this stage. That was the real ground for interfering into the issue. But in our case, the contention of the private respondent is that we are in possession. There is no question of any dispute, which has been already stated in their petition before the executive court. So apparently the present petitioner is in possession, and prima facie it establishes that petitioner, when petitioner is in possession, 447 cannot be attracted. Number one. Number two, civil dispute is a complete different thing. And if we now, I like to refer what is the contention? In contention is the private respondents when they are and stated that they have given a flat. But now the FIR, let us have a glance over the FIR.
We cannot again go into the main
Just as it is question of prima facie, in order to prima facie case has to be established first, and from the documents which has been relied by the prosecution, from the statement and from the FIR, nowhere no specification has been given. Only the contention that the order of the lower court is violated and the present petitioners have threatened. This is the only contention. And another contention which has not been supported in 161 statement. Now, my submission before your lordship is that specification, omnibus statement, by way of omnibus statement, a prosecution cannot run. In order to bring home the charge prima facie, overt act has to be mentioned. Neither in FIR, nor in 161, and nowhere it has been. In this regard, I like to refer before your lordship a case of our on the question of omnibus statement.
You want to cite again any further judgment?
Yes.
Then the matter.
Sir, this is being reply to reply.
Exactly.
But this is not permissible, my lord.
I know. Yeah, I can write down your argument. That is the omnibus statement cannot be taken to frame charge or cannot. I have already taken all your arguments, but I know the provisions of law. You don't have to cite any judgment as because it would take another complication. I would have again another to them to cite your contradict your judgment. That is the issue here.
Then my submission before your lordship, specification must be there. If there is no specification, no prima facie case is made out. No prima facie case is made out. What would be the consequence of the trial? In that case, trial would not bring home the charge. So entire process will be futile. Considering this aspect, I humbly submit before your lordship, it is a fit case wherein provision has to be entered.
My lord, I'll only take 2 minutes, my lord. I join issue with my learned senior friend who has submitted that not only the allegations in the FIR, it has to be taken as a whole. That is the findings of the investigating agency in the. My lord.
Yes. What is your submission? Yes, you have given the entire CD is there.
So the report, they have been reserving the order and violating the order of the Islamic court below. They had actually made the campus structure and it's the company one and they were to the report below. Can you give me? That will be filed. Yes, that is still my submission of the number of case for question.
Not a fit case for quasi.
Lord, am I audible, my lord?
Yes.
My lord, only two things, my lord. The 161 statements clearly reveals commission of the offences as made out in the FIR, and my lord, the FIR and the 161 statements, along with the other documents of the charge sheet, has to be taken as a whole, and that they make out a prima facie case against the accused person. Whether specific role is there or not, that will be tested, my lord. In my humble submission, during the course of trial, my learned friend's client will have a right to cross-examine.
Cannot give to the parties conference.
Your lordship is making it CAV, my lord.
Grateful, lordship.
Grateful.
Met CAV. Next.
আমার ম্যাটার তো নেক্সট মানে লাইন করতে 34 আমার item 35 মানে petition being infractuous মানে not মানে judgment already delivered before the court below মানে DB Act proceeding মানে infractuous মানে I want to not place this as
What is the requirement of CD? I have to pass the judgment.
Just I'm asking whether the CD.
Yes, you have the report.
That's the.
Please take down. The instant CRR has been preferred for quashing the proceeding being miss case number 147 of 2020. Under section 12, 18, 19, 20, 22 of the PWDV Act. 2005, pending before the learned Additional Chief Judicial Magistrate at Siliguri, Darjeeling. Stop. Next one. Learned Advocate, Mr. Hilol Saha Poddar. submits on instruction that the entire proceeding pending before the learned magistrate was disposed of. Accordingly, the instant CRR is become infructuous. So he intends to not press the CRR. Not press the CRR. So he intends to not press the CRR. Full stop. Next paragraph. Considering the submission of the learned advocate for the petitioner, the instant CRR be disposed of as not pressed. Next paragraph. An interim order passed by this court during the pendency of the instant CRR with CRR is also vacated. During the pendency of the instant CRR is also vacated. Next.
Number 36.
Next circuit.
Now 37.
Next circuit.
8.
What is the impugn order?
You have granted interim bail or telephone. Thereafter, as the directive to surrender, you are unable to surrender because it is being now we is my lord. Previously, it is when oxygen cylinder for some time. And there was one and two was missing. Can you see the two document, my lord?
So what you want?
My understanding of what is state, my lord, interim bail given on.
When you appear, you are on life support.
Some
Times means
time in 2 weeks
2 weeks.
or 1 week. As your lordship, my lord, he is seriously.
It's my charge is paid my lord.
I will cooperate.
He needs to cooperate.
I will cooperate with you.
Please take down. The instant CRR has been preferred against the order dated 21/3/2022 passed by the learned special judge, special court under NDPS Act, Siliguri, in connection with CR capital within bracket NDPS. Bracket close. Case number 75 of 2021. Thereby issuing warrant of arrest against the present petitioner. Thereby issuing warrant of arrest against the present petitioner. Against the present petitioner. Full stop. The learned advocate for the petitioner submits that the present petitioner was on interim bail by the learned special judge
By an order dated 5/10/2022.
by an order dated 5/10/2021. লিখতে পেরেছো? বলো। কতটা লিখবে? Learned advocate for the petitioner submits that petitioner
on interim bail by the learned special judge.
Learned special judge by order dated 5th of
October 2020.
5th of October 2021. Stop. He further submits that the present petitioner is seriously ill and now he is living with the help of oxygen cylinder. Stop. Accordingly, the present petitioner could not attend the learned special judge on the fateful date, that is on 21st of March 2022. What was the date? What is the date for fixed?
The date was fixed for on 6/12/2021. Para 6, para 6, I already.
Now, what is the date fixed for date? What is the date?
Para 6,
No, no. Why the date was fixed on 21st March 2022? Charge?
No, no, interim date. The interim instruction, there is a direction for appear, or in a CER, unable to appear.
No, I understand why the date was fixed for appearance.
Other point.
For appearance. For appearance. What is the name of the petitioner? Kalyan Dey. The case is taken up for hearing bail petition on behalf of Abdul Ghaffar. Okay. কি বলো? বল।
The learned special judge on the fateful date, that is on
Special fateful date issued an order of warrant of arrest against the present petitioner on the when the date was fixed for his appearance. Stop. The learned advocate for the petitioner has assigned justified ground before this court regarding the non-appearance of the present petitioner before the learned special judge. Stop. Next part. Considering the fact that the investigation is going on, I think it necessary to pass an appropriate order in respect of the issuance of warrant of arrest against the present petitioner. Stop.
warrant of arrest.
Arrest against the present petitioner. Stop. Next part. Accordingly, the instant CRR is disposed of with a direction that the order of issuance of arrest, order of issuance of warrant of arrest against the present petitioner, namely Kalyan Dey, be set aside. Stop. The petitioner is directed to appear, to surrender before the learned magistrate, learned special judge. On or before 30th of April. On or before 30th of April 2020. And shall pray for regular bail.
Remain on single, otherwise, may not be allowed. Remain on single.
And self-paper? And self-paper? And self-paper?
না কাটো কি বললাম
Surrender before the learned special judge on or before 30th April 2024.
On his surrender, the learned on his surrender, the present petitioner would be remain on same bail as granted by the learned special judge on the earlier occasion. Stop. Next paragraph. The learned stop. The petitioner is further directed to cooperate the investigating agency. CRR disposed. Character applications, if pending, are also disposed. Order of stay.
Is also valid.
My lord will be taking up criminal matters in the second half.
This matter at 1:20. I will call the list. I will call up the list after rising.
That is the only difficulty, otherwise we will not come to the law. If you doesn't hear it today or on Friday, we will be difficult.
Item number 7 is the parted matter. 7. Okay. After rising at another matter is PMI.
Your Lordship will be taking up criminal matters in the second half, my lord.
No, I'll take up this matter today.
Right.
At 2 p.m. Okay. Now.
Passion of the order, there's a minor change in lordship in the statement, and the second paragraph is stated as a statement has been filed by the OP. It has been by the petition.
Then why not mention at 10:30? Now.
Item number 54.
Shall I sit all day long? Nothing.
Lordship in morning.
একটা করে কাজ করাতে পারিস না তিনি জাস্ট একবারে বারবার করে একটা কাজে চলে
Item number 7.
Number 7.
Yes, my lord, I beg to appear for the petitioner.
Who is for the respondent?
My lord, Mr. Nobankur Pal, my lord. I have intimated him, my lord. That will be taken up. My lord, the order impugned, my lord, is, my lord, a rejection of my application under order 37, order 39, rule 7 for local inspection. On the ground that, my lord, allowing of this petition would amount to fishing out of evidence and nothing more.
Yes, what is your submission?
Yes. Now, if you Lord kindly text me, Lord, my application referred under, my lord, order 39, rule 7. What I, my lord, really wanted. It's my lord, page 20.
Yes.
Para 6, the next page.
No passover today. It will be appear on the next circuit. And let me hear out. Let me hear out. You take note. Take a pen and paper and take note. What?
He's also a party.
For the mayor's
Yes. Let you satisfy your matter.
Yes. Now, my lord, page 21 in my application, therefore it is accordingly prayed that your honor would graciously be pleased to allow the prayer of the plaintiffs for holding local inspection by a survey knowing advocate commissioner to appoint an advocate commissioner to inspect the suit land on the points given herewith, or to ascertain the following things for the ends of justice: nature and character of the scheduled land, topography of the suit land, length and breadth of vacant space left in scheduled land, to prepare a rough sketch map showing the scheduled land and the nature and character of scheduled land, any other local feature or features. This was, my lord, what was prayed for. Now, my lord, kindly takes the plaint once. The plaint starts from page 11. The allegation was that the plaintiffs are residing adjacent to the suit property.
Where are you residing?
Where
are you residing?
Para 1. Para 1 of the plaint at page
adjacent of the suit plot.
Yes. Kindly, my lord, takes para 1. That the plaintiffs are residing in the northern side of the land purchased by the defendant number 1, 2, 3, jointly fully mentioned in schedules A and B below.
Yes. Northern side of land means what?
Northern side of the land, which is at the northern side of the schedule A and schedule B land.
What is the number of your land?
That has not been disclosed in the land. That
What
has
is
not
your
been
right?
disclosed. No, my lord,
what culminates your right there?
No, my lord, so far as, my lord, an allegation of illegal construction is concerned, my lord, mere non-disclosure, where I have specifically stated that I am at the northern side of the scheduled land.
What is your prayer in the suit plot? In the suit?
Yes, my lord, kindly takes, my lord.
Yes.
Decree declaring that the construction is in violation of municipal rules and disobedience of municipal sanction is unauthorized and illegal in the land fully mentioned in schedule A and B. That is, my lord, my prayer.
Your prayer in the suit?
Prayer, my lord, in the suit. Now that cannot be improved. That cannot be improved at this stage.
Whether that can be entertained in the suit?
My lord, they have not taken this point in the written statement.
No, you have to satisfy this revisional court before getting any order.
No, my lord, abide by that. My lord, that's absolutely right. But kindly, if my lord kindly takes the written
right
statement.
You have your right has been clouded or violated.
that has not been disclosed, my lord. It's my lord, kindly sees, my lord, in the plaint, my lord would find the allegation is that without leaving the statutory 3 feet space, they have started a construction.
So you have to prepare a specific application before the appropriate authority.
That is right. They have not done that, but that does not, my lord, hit, my lord, at the root of the plaint, to my limited understanding.
You have filed a suit for declaration.
Yes.
What declaration you want?
My lord, the declaration, my lord, the language.
For the land property of others.
My lord, the direction for demolition, direction that the construction is illegal. My lord, the prayer ought to have been better, stating, my lord, on the light of
Then you come with amendment, otherwise it.
My lord, easement, it should have been best.
Yes.
But at best it can be a case of, my lord, violation of easement-ary rights.
Easement-ary right, you are not claimed easement-ary right.
That has not been claimed. That has not been claimed.
So how can you entertain?
My lord, I am covered, my lord, with 2 judgments, my lord, I am carrying. I can demonstrate, my lord, in the instant case, if I can cross the first hurdle, which has been posed by your lordship, if I can cross that, that fishing out of evidence would not be applicable in the instant case. Now, my lord, subject to correction, my lord, the prayer, my lord, since it has been disclosed in the plaint, in the pleadings, that instead of leaving the statutory space, they have raised the construction, my lord, the prayer can be subsequently amended.
No, you have not pleaded. What right you have, your right have violated?
My lord, kindly, my lord,
whether any light or ingress right, whether light, air, everything, whether any easement-ary right was violated, you have not pleaded in your plaint. I have read out entire matter.
My lord, that has not been pleaded.
Then,
that cannot be improved.
Then
that cannot be improved. But my lord, there is
what you trying to establish by local inspection?
My lord, so far as that is concerned, my lord, I'm covered by a judgment, 2 judgments in fact, which says that wherever there is an allegation particular to the construction, even that is not in the suit property, even if that is not a suit property, the court can always allow an inspection under 39 Rule 7 only for the
subject
purpose of
the fact you have your right in your suit property. You must have pleaded that you have a suit property beside the plot.
Now, my lord, admittedly, in the written statement, corporation has stated that there is no sanction plan. Corporation has stated. Now, my lord, I don't know why corporation is opposing me. They should not oppose this. Now, my lord, the pleadings are, my lord, not, my lord, I would say, my lord, it is not at all satisfactory. It cannot be improved also. But
yes,
perhaps, my lord,
what you want to show?
My lord, I want, my lord,
judgment.
Yes. My lord, will first take, my lord, the Odisha High Court first, then, my lord, the Calcutta High Court I will place. That I take to him. My lord, para 7. In the aforesaid background, the question relating to inspection of disputed land as provided under Order 39 Rule 7 CPC is to be considered. Trial court is not correct in stating that acceptance of prayer of defendant number 1 would amount to rendering him assistance to collect evidence. The report of a commissioner appointed under Order 26 Rule 9 CPC shall be evidence as provided under Order 26 Rule 10 CPC. Report of inspection shall not be evidence unless otherwise proved. Power under Order 39 Rule 7 CPC is not frequently used. This is a power to be exercised by the court when occasion demands and when inspection is necessary for proper appreciation and adjudication of the matter. The dispute in the present case relates to the situation of the disputed land, the nature of construction made, and the effect of such construction on the house of the plaintiffs. So, Milord, here we find some similarity with the facts.
What effects over your land?
Milord, that has been pleaded, Milord. Kindly seize, Milord. Milord,
very well. Next judgment.
Milord, Milord, the next line. While plaintiffs claim the disputed land to be part of the dwelling house, defendant number 1 claims that he has purchased vacant land adjacent to the dwelling house of the plaintiffs. Allegation is relating to construction of house by defendant number 1
which plaintiffs intend to arrest during pendency of the suit. Defendant number 1 in the written statement, he has already constructed the local inspection of the disputed land and its adjoining areas, would give a clear picture to the court for considering the question of temporary injunction which is pending. The same does not amount to collection of evidence in the case.
Yes.
This is Milord one. Milord, the second is Milord, it's by Milord our court. Milord, a coordinate bench. Milord. Here, Milord, the entire scope of Order 39 Rule 7 has been considered. Milord would take page para 16. Para 16, Milord would also find that Milord, the leading judgment in this, that Order 39 Rule 7 may amount to fishing of evidence. Milord knows that is Milord the Bengal engineering judgment, Institution of Engineers judgment, I'm sorry. That has also been considered. What would amount to fishing of evidence? Now, here, para 16, Milord would find the points which were submitted by the petitioner for inspection by Advocate Commissioner. These were Milord the 7 points on which the report was called for. Para 18, para 19 Milord would take. Upon considering the application under Order 13 and Rule 7 of the Code of Civil Procedure filed by the plaintiff petitioner, it will appear that the petitioner alleged violation of the order of injunction of the learned trial court and the appellate court with regard to B and C schedule properties and carrying out construction in violation of building rules. Thus, for the purpose of preservation of suit property, it is necessary that the local inspection should be carried out with regard to point 1 and 6 of the schedule as submitted by the petitioner. As points 1 to 6 are interrelated, inspection should be carried out on all the points mentioned in the schedule and none of the points can be ignored. As Order 13 and Rule 7 of the Code has empowered the court to make an order for detention, preservation or inspection of any property which is subject matter of such suit, and for the said purpose authorize any samples to be taken or any observation to be made, so and so such order when necessary for preservation and inspection suit property should not be refused on the ground that it will amount to fishing out of the evidence for a party. Thus, the order of the trial court cannot be sustained without modification. It was modified to the extent that, Milord, some of the points were considered, some of the points on which the inspection was sought to be carried out were asked to be ignored.
Yes.
Now, Milord, kindly take para 11 of my plaint. Milord would take para 5 first. Para 5 of the plaint. That the plaintiff subsequently did notice that the construction was carried on by the defendants not in compliance with the municipal rules, obviously without obtaining any sanction, as the mandatory vacant space was not left out by them. Second, para 8, they have lodged a complaint before the local councillor who Milord failed to take any action. On the first occasion, they visited, intervened, directed the defendants to show the necessary sanction plan for consideration. They could not. 9, then continued with the construction. 11, that the locality is thickly populated, roads being narrow, municipal authority ought to have been more vigilant in respect of strict compliance of the municipal rules, as also close adherence of the municipal sanction. But strangely, the authority was found reluctant and indifferent. That the said go down illegally constructed by the defendants on the schedule below may fall down on the nearby building, causing huge loss of properties and lives, as no safety measures have been taken by the defendants for protection from natural disasters like fires, etc.
Yes.
So, Milord, even though the prayer is not couched, Milord, as it could have been, Milord, that no grievance has been ventilated by the petitioner against the defendant, Milord, probably that is not entirely correct. So my lord, the plaint cannot be said to be absolutely devoid of cause of action. Though my lord, it could have been worded properly. Now my lord, having said that, my lord, kindly see the written statement also. Because in the written statement, they have never taken this point that the suit does not disclose any cause of action. It is a bare, my lord, deny dispute, nothing else. And therefore, my lord, I would say that this point cannot be taken now or cannot be raised now because the entire thing, my lord, would suffer from doctrine of non-traverse. My lord, kindly see the written statement once at page 33. 33, my lord, is the corporation's written statement. Kindly, my lord, kindly sees at para 8. Para 8, corporation has admitted that they could not furnish sanctioned building plan of the said construction. They could not produce the sanctioned building plan of the aforesaid premises. I mean, from the written statement, kindly sees, Milord, I could not find even one line where allegations in the plaint has been substantively denied. Or it has been urged that the plaint does not disclose any cause of action. No Order 7, Rule 11 taken out. Milord would have just a cursory glance, page 26, 27, 28. Kindly sees how it has been dealt with.
Yes.
Now, Milord, today while considering, Milord, this impugned order, Milord, I believe, Milord, I would be able to satisfy, I have been able to satisfy your Lordship that the points which has been urged in the 39 Rule 7 application would not tantamount to fishing of evidence. It is only, Milord, that's why at the first instance I have showed your Lordship my petition under 39 Rule 7 and what I have sought. It is only with regard to the nature of construction, the description, Milord, page 21, nature and character, length and breadth of vacant space, and or a rough map showing the scheduled land and topography of suit land. That's all. 39 Rule 7 automatically does not go as evidence. And even if these details are brought...
What about the vacant land?
Milord?
What about the vacant land?
That is judgment for the purpose of adjudication, because unless it is, Milord, unless it is ascertained...
You just take the question, then answer.
Yes.
What you want about the vacant land between the land of the plaintiff and the proposed construction?
Milord, that would prima facie demonstrate whether there is any violation of the municipal rules or not.
No. Again, you are turning it. I want the specific question.
Milord.
What the commissioner shall report regarding the vacant land of suit property and which land?
Scheduled land. I have said scheduled land.
Scheduled land?
Yes.
And the vacant land of what?
Length and breadth of vacant space left in scheduled land.
Scheduled land means?
Scheduled land
means the land of the others.
The land of the defendants. Now, unless that is ascertained prima facie, whether there is a prima facie violation of the municipal rules or not, whether that 3 feet space, 3 feet vacant land is there or not, but without an inspection, how this can be ascertained?
Very good. Yes, anything further?
And Milord, the judgments which I have placed, Milord, it says that 39 Rule 7 automatically does not amount to an evidence.
Yes.
It is only, Milord, for a prima facie inspection, for a prima facie impression of the court that what is the allegations pleaded in the plaint and what are the sanctity of those allegations. Whether it is prima facie tenable or not, subject to further proof at the evidence stage. So at the ground, merely the single ground on the basis of which this application has been rejected, that it has been cryptically, it will amount, tantamount to fishing of evidence, my lord, according to me is perverse.
Yes.
That's all, my lord.
Yes, reply.
The judgment relied on by my learned friend with regard to the High Court judge. It is only for preservation of the interim order of injunction granted by the court below. Because of time is seized. There was an order of injunction that was asserted whether paragraph 6 there is issue that proceedings of beating written over all for having violated order of expert injunction. There is no doubt that as order of restraint passed by the order must be respected. This is for this related order. And not can see explain one of the release plate problem. For degree declaring that the construction in violation of municipal rules. Declaring the construction in violation of municipal rules. And feasibility of sanction is unauthorized and illegal in the land to be mentioned in city land. For a degree we pass declaring direction of donation of the construction which are found to be unauthorized and illegal in scheduled land mentioned in A and B. From their own brain, they have to canvass the violation fund, which they have not done. Now, by filing this application, Madam, can you see the application, Madam? What is the purpose of filing this application? The plaintiffs have submitted the defendant number 1, 2, 3, 4, and 6 appear before the United Court through their duly appointed lawyer and paid for filing W against the injunction petition. The appeals against the suit, the defendant filing did not turn up before the court. The defendant also accepted before the United Court after receiving some. Therefore, the feature of this property is remote essential refer to be brought before the United Court. So, these are all meeting out of it.
Specific relevant. Specific relevant. Yes.
Can you see what they want to assert about the nature and character of food land, topography of food land, layering and breadth of the vacant space, layering scheduled land to prepare a rough sketch map. The reasons for inspection of the concept points has to be first ascertained. What are the reasons? That type of disclose. They say nothing now. With regard to that. They are failed to canvass the violation on the trade. Now they are trying to get the property inspected.
Yes.
So this is simply fishing out of the order passed by the court below is absolutely right now cannot be interpreted.
Is anyone appearing for the municipality? Yes, what is your submission? You have no submission. Very.
They have admitted that there is no sanction. In reply, I would say you got 2 lines. So far as the deficiencies of the claim, even they have canvassed nothing in the written statement. No point has been asked.
Yes.
At this stage, the application mark. Not the. If the suit fails in its natural fate, it will happen. At this stage, they cannot take this point. So far as the suit is concerned. And considering the prayers and the prayers of 39 Rule 7, it is absolutely equal. If I allege illegal construction on the basis that the statutory space has not been left out, it requires to be ascertained whether there is a vacant space between the scheduled landlord.
What does it mean?
It means whether there is any.
You have not stated in your plaint what is the nature of the property, suit property.
Stated that
Say,
vacant space has the statutory space has not
state the schedule, see the schedule.
Yes, schedule is their land.
Schedule is their land.
Their land.
You want to inspect over that land.
No.
Then
the first para of my claim that I have shown you.
No, what you want inspect.
I don't want to inspect. The commissioner would inspect them.
Yes. What report you want?
As per my application, you could find it is very categorical. What I have sought for. Nature and character of the suit land, topography of the suit land, length and breadth of the vacant space left in the scheduled land, to prepare a draft map showing the scheduled land and the nature and
Scheduled land means the land of the defendant.
Land of the
defendant.
Yes. Now, Millard would also appreciate this. Millard, so far as illegal construction is concerned, I being a resident adjacent to the northern side.
You have the other authority to demonstrate.
I have done that. I have made an application before Mr. Dodds plan, nothing is put up. They have inspected, they have said there is no scientific plan, but they have not taken any action. And
that is the separate authority, this is not for the suit.
We are not on that. We are not on that. Probably 226 jurisdiction would have been invoked or whatever. What has happened here, going to the root of the plate, privacy, I cannot see it is absolutely bad or this inspection, prayer or inspection could not have been.
I want to say what is the nature of the scheduled suit plot. Whether you have stated anywhere, it is jol, it is kala, it is bastu or everything, anything.
The classification has not been
Then what nature, character, what you want to prove?
Para 2 and 3. Para 2 is the schedule A plot, para 3 is the schedule B plot. I have specifically stated pursuant to which deed they have purchased it, recorded it probably in their name and have started making a construction thereof. That is what visibly I can see. Miller understands the limitations of a plaintiff. Being an adjacent suit owner, I can only see what is happening and what is causing prejudice to me.
But what your suit remain under section 34, you have declared a decree, but your suit has not. No, I have to go. Whether you have any right to inspect over the suit property of others.
Right.
I cannot allow you to go to any suit property of the others by virtue of a suit. You have not pleaded any right. What right you have violated?
If we go by section 34, the language is very clear.
Yes.
Right status.
Yes. What status, what right you want to protect?
The only limited infringement of my right would find a pedophile. Where I have stated that the statutory space that was required to be left out has not been left out by them, and their construction has.
But what right you have, your right have violated?
That has not been.
Then
I cannot do.
How can I proceed, allow you to inspect the suit property?
The necessary correlation.
Hereby, visit the under order 39 to 7 of October. I the suit for declaration to put the they will get the proposed for defendant number 7. Proposed defendant number 7. I have also contested the suit by filing separately. This one, you also cite it for some. The number of the the local expression was not for on the basis of both A, nature and character of the system, B, topography of the system, C, length and place of vacuum space left in the civil land, length and place of space left in swift land, D, to prepare a rough sketch showing the schedule land and nature and character of the schedule and nature and character of the schedule. Five, it must have detailed the nature and character. The application. 30. We have only one. Exactly. Not possible. Next. Not recently. Next. On the 30. Apart. Number of them. Again, it will be misplaced, and again, it will be again the next circuit, it will be, I have handed over. This has to be annexed with the plan. Why not annex this? That you have complied the order. Then it has to be annexed. Justice বিশ্বাস. Yes. Where is the reflection that we have hide the money receipts or otherwise? You have paid 6,000, 4,000.
10,000 I have to pay. 10,000 I have to pay. 3,000.
File it. Otherwise, it cannot be taken into account. By your submission, it cannot be taken into account. Now, deposit has been made after the 10 days. Then, file specific application. Otherwise, file specific application. Specific affidavit, right? Affidavit, yes. Yes. Please take down. Direct supplementary affidavit in connection with grant 1 of 2024. That appear in the next level. Stay there. Let me check. Next level. Order of sleep on which on the earlier occasion. The further extension. In the second day of the second day of next level. Give me your
সেকেন্ড ডে অফ নেক্সট স্টেটের নামটা নিয়ে নেবে, ওপর লিখে দেবে স্টেটের উকিলের নামটা ওপর লিখে 3 p.m. fixed matter.
Number 8. What is the 43 of the last application? I have been directed to serve the server copy on the original order for which the execution was obtained. And because it was displayed, I have the server.
Give me the item number 43.
43. Server copy was displayed and was directed to server copy on the
What server copy?
the original order. This is the execution case against the order. What is the palace I have prayed for a interim order of stay, and your lordship was pleased to find out the server copy of the original order, which was for the exporting against me.
Is there any direction to find?
Normally, your lordship was
Nothing is there in the order.
your lordship was pleased to fix it for further head.
After hearing, I have not started the hearing of it yet. What is this? Server copy? Why not the certified copy? Have you not filed the certified copy?
No, no, this order has not been challenged.
Then
I have challenged the order of the execution case. In execution case, without complying the legal formalities, anything the page number.
okay, this is the order
This is the
on the
original
basis of which execution case.
execution was.
So why you not file this?
Actually, that was this case.
So what you want now?
I'm very
You want to use this? This thing can be taken like that in the High Court.
Well, I have already filed that in this case, and your lordship was pleased to ask me.
No, I cannot allow you to.
Then I'll file a supplementary.
Yes. Please take down.
Well, I'm for the statement.
43 হবে এটা next. Item number 43 হবে, ঠিক আছে? Petitioner is at liberty to file supplementary affidavit along with the server copy of the order. Server copy of the order passed in Miss Petition number 182 of 2011. Of 2011. Let the matter go out of the list. Party is at liberty to mention. Let the matter go out of the list. Parties are at liberty to mention. Yes. Fixed matter? No. After this matter, it will take 5 minutes. I have already concluded this. Also appear in the next one. Very well, all with the can is to appear in the next one. Yes. No. Come on next level. Okay. What is the matter? Yes, I'm getting you. That's fine. Correct.
Master order that I defer that matter. So, it is there is a pending or matter for the from that and I point other about and pay that was Jamania and it would get that more not within the time for compliance of the one and two of the data. It called out from the above judgment and equal application. Both pivot 1 and pivot 2. Hoping the relevant portion is stopped by an order agent of a judgment. Observe that the hypothetical example was not confused and section 5 of the incident and the manner of application of the intended of the intelligence alone the category or it is deciding on application under section 1 and 2 of the data. What for us whether opponent as a binding that of the which one Jamaica were not fundamentally correct. This is the high court set aside the order of dialogue. How is the application under the of the data and participated basis of it. The data approach the available appeal. Appeal approach putting the fact character to one to put judgment. With the character number 5 as done. Which side the side. There is no room for it doubt that honorable aspect. Propose certain or finally the scope and the of the act. Section 7.1, 7.2 and 7.3. That was the case first that it was not depicted by the I am not taking last time of the year. I am some character of 15. Yes. Section 7 was of Jamadia and the area taken by and put on the ground of fraud was considered and the proportion of the state by the following character. Paragraph 19. Subsection 1 of section 7 of the Act begins from the state on the ground of non-of India rate. It is the landlord. Or deputy speech that all area of rate calculated the rate and after the of the month that apply time and describe word that is 1 mark of the speech of the summer or purpose of appearance amount and written by there's no requirement of filing it or not. Only required with the two criteria for distributing the relationship or the amount of. Therefore, and amount of price of the ad. Time for this of picture of it. And price is not and not right for one part of one half of appearance without and also and the system of Inter and the concept on of the Inter of the is the of the next level of the act provide for a complete system for ability of the ground of the state provided that it is and concentration of the level of that is the idea they complete on determination of the system that is of the value on the function approach on the ground of non-payment of years. So thereof, data not six of five. So this is that as not an application alone was defined by the data, but the data has to be has been. So this is the paragraph 19 of Punal Samaria method that was referred by the while like this paragraph 16 most of the result and but with this by statement of that. The conjoint of paragraph number 19, 20, and 21 of Commission Commander would categorically reject such findings. Section 40 of the same Act makes the limitation applicable to the provision of the same Act subject to other increased period of limitation in the statute. The Honorable the provision of law and held that Section 5 of the Legislation Act does not apply if the tenant fails to comply with the mandatory provision of according to the HOD Commission Commander, the period of 1 month as mentioned in paragraph number 7.1 was stated in field of limitation, making it part of the same as inactive. Thus, the system of the cannot be accepted as good law. The decision was rendered without considering paragraph number 19, 21 of the Samaria. The decision is to had been distinguished in Calcutta Gujarati Education in which section 40 of the State Act was considered but negative upon discussing the decision of Samaria. The law was cleared by the Appeal Court and it was the issue of the High Court and in accordance with Article 141 of the Constitution of India and applied the High Court not overruled the decision of the Honorable Appeal Court on the ground that Appeal Court had based out the legal position without considering section 40. Not only a matter of for the High Court, but also a mandate for the Constitution that provides in Article 141 that law declared by the binding on all courts in the territory of it. All subordinate courts to the Honorable Appeal Court are bound by all declaration of law made by the Court, even when the facts of the case decided by the Honorable Appeal Court. In Maria was a case cited on similar facts arising of the and now the principle governing the 7 and 7 along with section 40 of the there is no scope under Article 141 with Appeal Court while it is most matter came to a finding and conclusion that section 5 or any other stand not applicable in respect of 71, 72, 73 because 71 application limitation is inbuilt. Therefore, would have been scope to reconsider this matter and the additional application does have no meaning and liability. Dear Lord, what that is not an issue. I understand your issue. Your issue is that whether section 7C, section 7C declares the liberty to the tenant in respect of 7.1 and 7.4. Provide. or, not and. And the subsection two, subsection and start, official start with colon, not in separate otherwise. Colon means is continuation of subsection two. It is not continuation of subsection one. Part of it, not part of one. Or if you are regarding or, conjunct, not conjunct, just the term or is it. Para 21. There is a joint application by the prosecutrix as well as the accused. Primary prosecutrix. I may take your lordships to page number 12, which is the FI written complaint treated as a FIR. Some of the allegations are limited to only one aspect. Prosecutrix came into contact with the accused who were dating number 12. That is in envelope. Why envelope? Because there has been a direction that the names of the prosecutrix should not be included. Allegations are simplistic. Allegations simplistic are the prosecutrix alleged that she came into contract with the accused through a mobile dating app. Thereafter, they started seeing each other, and thereafter, they were in a love affair. For almost 2 years, they continued in a love affair. And during this course of their love affair, the accused used to take her to his home as well as to different hotels where they used to have coitus on the promise of the accused to marry. Yes, this is the FIR. On the last occasion, the prosecutrix, since the accused and the prosecutrix were having some turmoil on their relationship, they were not, their relationship was not going smoothly as she alleged. They went to Kolkata for spending some quality time. They boarded in a hotel together in a room, had coitus there, and then she found out that his marriage has been fixed on some odd date with some other person. And out of a rage, they had a scuffle. She immediately came back to Siliguri and lodged it. After lodging of the FIR, the accused was arrested. He was then released on bail. But then, the misconception of the prosecutrix, which was the outcome of her rage, now were all eradicated. They are in they are continuing with their affair. They have filed a joint application. If I may submit, but there are certain offences, I humbly submit, which bear serious impact on the society, puts the conscience of the society. But they are not subject to passing by this honorable court. But certain offences are there, by nature of whom has to be included within the genre of private offences. So this kind of from the allegations itself, it calls out that this particular offense is an offense which is completely private in nature between the prosecutrix and the accused. Moreover, now it is settled law that to establish, prima facie establish an offense under section 376 read with 470, the prosecution after completion of investigation must establish that at the very inception, when the promise was being given, it was false. Now, the investigation has culminated in that there are no material as such which simplicity indicates even that at the time of the inception, when the promise were being made, they were all. They have filed a joint petition. Their misconceptions have been eradicated. Charge sheet file, charges not framed. Not framed. Out of rare, out of a misconceived state of affairs, she lost this complaint. Later she understood, when things were open, before her conclusions were eradicated, all misconceptions had been eradicated. She has joined those in the petition. Grand application. Amount to abuse of process of law, wastage of much precious judicial time. This aspect can be considered as possible. Had it been a case of possible violation? The case where the allegation is there was a promise to marry, and subsequently she sees that will carry will take to some other thing. And out of rage and misconception, she immediately lodges paper. Can you see the incident happened and the next day she boards the train and comes to school and lodges paper. In a haste, it all happened in a haste. Later, she understands everything and misconceptions were dedicated. Judgment, they are not holding the case. Honorable Appeals Court has clearly said that in a case of compromise under 320, section 320 will not be a bar. This is not a case of compromise, but where the FIR was lodged in a haste out of rage and misunderstanding. Sometimes this mistakes happen.
kindly bar but because your lordship has heard the matter, your lordship has gone. Her pattern has come up the next year. Then, my lord, kindly keep it on Friday, my lord. CD camera is Siliguri will open tonight. I have already discussed all the matter. My lord, then kindly pass an order for staying the proceedings in the class. Not grateful. Ready? Right. I cannot say date like. No, it cannot be like that. I passed the matter and passed the hearing. What is the
get to the and again, here from the yet immediately, here I got to a lot at a lot in now deciding about next. Correct. Kindly take item number 54 along with 50. It is between same parties touching the same subject. Entirely same. The issue there is the order for local inspection passed under order 39 rule 7. This petition, innocuous prayer has been made for expediting. Yes. Yes, kindly take it up, madam.
order was passed which is bereft of any reason, a single line order without recording any findings to the satisfaction of the learned trial judge. If I may take away, you serve that, you serve and come. Yes, my lord, kindly stay the order, my lord, because this, what is the requirement for stay? My lord, if the local inspection is being conducted, which has not now been conducted, my lord. Till now it has not been conducted, but if it gets conducted, my lord, they will come and claim a kind of equity, my lord. Kindly come to page 91, my lord. This is the impugned order. Order dated 2nd of March 2020. Yes, my lord. The petitioner. 1 year. Yes, my lord. The petitioner is 1 year. Yes, my lord. My lord, kindly allow me to explain, my lord. The petitioner is a senior citizen suffering from motor neuron disease. It's a very serious neurological disease. Kindly see, my lord. Learned, I'm reading it out for my lords. Learned lawyer for the defendant, the petition under Order 39, Rule 7 CPC is taken up for hearing in presence of both sides. Learned lawyer for the defendant raised strong objection against the petition for local inspection. On the other hand, learned advocate for the plaintiff praise for local inspection of the for adjudication of this. Are both sides? Considering the whole aspects, Gopal Mujumdar, learned advocate, is hereby appointed as a feeder commissioner to hold commission over this property as per points mentioned. 191. No reasons, no findings were written by the learned advocate. Otherwise, I will be what would be done? Yes, ma'am. Because that will amount to missing of but the opposite party original title. When it put under why the 1 year has been elapsed because it has not done? No. Why not? There is another thing. Where is it now? Yes, my lord, my lord. My lord. And the hearing of the matter. Okay, it said down. Let's put the matter be fixed together. For here. Right. Kindly pass an order that the order impugned will be subject to the outcome of the always there. I have admitted you to the application. Difficulty is not in the meantime, if the feeder commissioner submits the report, one of the only plea the opposite party will take that the report has been report will go away after the so one line on my kindly acknowledge your is a knowledge of market.
What about the state? What is next? Huh? What? Let it be five that always. What is the first? No, no, no. Second thing, Jalpaiguri transfer place of Please sit down. Not high enough. Where is the state? I have to heard the state at least. Last chance they have to file the opposition. Opposition is not required now. Last day of net development. Last day of net development. Net development. What if it's item number six? I am appearing with the respondent.
Item number 66, I appear for the petitioner, my lord. There is no, I cannot hear any of the proceedings, my lord, online.
I'm not taken the item number 67.
66, I appear for the petitioner, my lord. I have been appearing, but nothing is audible, my lord.
My lord, in item number 64 also I am appearing for the petitioner, but my lord, your lordship is not audible, my lord.
Nothing can be heard at all.
What is 11? All the leaks.
My lord? Item number 66, my lord, kindly takes it up, my lord.
What is the matter?
The application under section 24 for transfer of a matrimonial suit, my lord. The application for transfer from Fast Track Court Shiliguri to District Judge North 24 Parganas at Barashat. I appear for the wife petitioner.
Service not complete.
Service is complete, my lord. Affidavit of service was filed on the last occasion, my lord.
back, not delivered.
No, my lord, they appeared. They appeared and prayed for accommodation. My lord, kindly seize last order, my lord. My lord, they appeared on 3 different occasions. They prayed for adjournment.
Now where is the?
I don't know, my lord, my interim order was passed by justice. They, my lord, interim order has since expired. Since they have not appeared, they prayed for accommodation on 3 different occasions. Justice before Justice Basu as well, and before my lord on last occasion. And I was protected by an interim order of stay of the matrimonial suit. Well, if they don't appear, my lord, let the interim order be, let me be protected for a certain period of time, my lord.
Get on your.
Well, let there be no interim order, my lord. Extension thereof, my lord. My lord, my lord is not audible, my lord. I cannot hear anything, my lord.
Your interim order was extended.
I'm grateful, my lord. I'm extremely grateful, my lord.
May I mention one thing, madam, item number 64. I'm appealing for the petition amendment.
Hard support of my days of 2004. And one of the an application for one of the I go that there is more detail than one of the I think that more weeks there. directed to find the certified copy of the report. Then,
some other documents also, certificate copy applied for together.
Coming to last page, wherein it is mentioned that it was applied point, right?
That the this
That the certified copy of the order doesn't contain the relevant date for filing of application for a certificate of and other and etc. Rather than the application. This that by the
But the same problem is occurring in 70, 71, 72, 73, and 81. I shall bring the Xerox copy on the next day. Because all the copy are not available. On the next day. Right.
So this matter you give.
Yes, this matter I am giving. This matter we give, but all the other copy is lying in the house.
Item number 70 to 73.
72, 73, and 81. And 81.
81 not today. Not today.
Yes.
One of my staff has left because of that. The penalty is there for 3 days. Give me the 70. Now, whether it put it or not. That's why you have taken the steps. Very well, please take on. One of them. that there are 555 days delay. Referring to seven. Oriental Insurance Company Limited appeal. 75, 76, not two. If you file the form. Common file. Not today. Next. Then pick. That is the five. Five, five, the director Gandhi. Direction was there for years of July 2020. And have not complied. Serve the copy of the application upon all the responses for the thirteen. That was 78. Get by 70 days.
Madam, I have filed 2020 lordship with a period of progress. Lost my. How do I report that you have not visited the center? I've lost my.
Get and pass. They are not violent. 6.